For judgment item number 1, WPC 12853 of 2014 and WPC 14423 of 2014.
We have not disturbed the finding with regard to violation of Section 25F of the Industrial Disputes Act. But so far as finding with regarding reinstatement in previous post, that we have modified it pursuant following certain decisions of Honorable Supreme Court, and allowed with monetary compensation, keeping in view the length of service rendered by the workman. We have said this court made estimation of such compensation, which is arrived at 1 lakh rupees. In the result, this court is inclined to modify the award dated 6/3/2014 to the extent that workman Sri Ganeshwar Panda shall be paid monetary compensation of 1 lakh rupees in full and final settlement of his claim. The amount shall be paid by IDCO within a period of 3 months from today, failing which the said amount shall start earning interest at the rate of 6% per annum from the date of this judgment till actual payment of the amount is made to the workman. Consequently, the restrictions 14423 of 2014 and 12853 of 2014 stand disposed of with the modification of the award dated 6/3/2014 of the Industrial Tribunal to the above extent, but in the circumstances there shall be no order as to costs.
I agree.
No, my lord, your losses specifically directed
All right,
to
all
give
right.
the appointment letter, my lord. Not
All right,
to
we'll-
only document and judgment.
We will see. We will see.
The parliament's judgment has been delivered.
We will see.
My lord,
नमस्कार साहब, महिला हमारा जो है हिंदी भाषी होने के नाते सुनवाई नहीं हो पा रहा साहब। हमारा 13 मार्च को डेट दिया गया था, 20 मार्च 2000।
क्या है मामला?
सर्विस मैटर है साहब। और ये साहब फिर हम 4 बार मेंशन किए लेकिन कोई सुनवाई
नहीं, सुनवाई होगी आपकी। आप का क्या है, ये अपील है या रिट है? क्या रिट अपील है? कब फाइल किया आपने?
2021 का साहब। काउंटर डिजाइनर 2022 में कंप्लीट हो गया, लेकिन हमारा सुनवाई नहीं हो पा रहा था।
हो जाएगा।
जब भी हम आते हैं 25 मार्च मई में आए थे साहब, तो बोले कि जो 25 मार्च को आज भी लिस्ट नहीं होगा, इसलिए साहब आपके पास आकर
गिव योर स्लिप
साहब। कल अगर हमारा सुनवाई
कब आएंगे? कब सुनवाई करना चाहते हैं?
साहब
कल। ऑल
क्योंकि साहब स्टेशन पर सोते हैं, कोई जगह नहीं हमारे पास।
ठीक है। और टुमारो 10:30 ठीक है। 10:30 में आएंगे, आपकी सुनवाई 10:30 बजे होगी। दिस इज रिट। आपने आपसे कहा, पूछा मैंने कि अपील है कि रिट पिटीशन है, आपने कहा अपील है। ये तो अपील नहीं है। यहाँ तो मेंशन नहीं कर सकते हैं आप
साहब। आपके पास इसीलिए क्योंकि हमारा सुनवाई हो नहीं पा रहा
तो
है।
वो तो हम नहीं कर सकते हैं। किनका बेंच चाहिए?
मैंने लास्ट ऑर्डर का देख दिया।
आप गोरखपुर से
1 मिनट रुकिए। आप कल आइए। आप कहाँ से आते हैं?
गोरखपुर से। गोरखपुर यूपी गोरखपुर।
और यहाँ कहाँ पे रहते हैं?
स्टेशन पर। स्टेशन पे चादर बिछा कर सो जाते हैं।
तो आप क्या वो कोई सीनियर वकील साहब को आपकी तरफ से कर देते हैं?
अब हमारा
आपको तो ये भी पता नहीं है कि ये रिट अपील है कि रिट पिटिशन है, तो आप अपने केस का क्या ये करेंगे?
अब हमें बता देंगे साहब।
आपकी मदद के लिए अच्छे किसी लॉयर को आपको ये कर देते हैं, कोई लॉयर आपका केस कर लेंगे।
शांतन सरंगी साहब हैं लेकिन कोई सुनवाई करते नहीं साहब।
सुनवाई करेंगे ना? हाँ?
कई बार बोले तो
एक मिनट, ऐसी बात नहीं करिए, ऐसी बात करिएगा तो आपकी सुनवाई नहीं होगी। ये कहिएगा कि सुनवाई नहीं करते हैं तो आपकी सुनवाई नहीं होगी। आपको सहायता दी जाएगी, लीगल एड दिया जाएगा। आप चाहिए तो एक अच्छे लॉयर को आपके तरफ से बिना पैसे के ये कर दिया जा सकता है। बताइए।
शांता सरंगी साहब को मिले हुए हैं साहब, लेकिन वो बोलते हैं हम
आपको कोर्ट से बाहर निकाल देंगे इस तरह की बात करते हैं तो।
साहब हम अपना कुछ करेंगे साहब।
नो क्वेश्चन। अब कैसे इस तरह की बात बोलते हैं कोर्ट में?
साहब जानकारी
जानकारी नहीं है तो कुछ भी बोलेंगे। और आपको कोई लॉयर चाहिए कि नहीं, बताइए। नहीं चाहिए तो छोड़ दीजिए, नहीं होगा लिस्ट, रिजेक्टेड।
item number 40 मतलब item number 40 मतलब
यस
मतलब kindly taken up today मतलब kindly taken up
भाई
मतलब Arbin council coming from Delhi from yesterday and staying in hotel मतलब previously honorable court fixed a date today and this case listed 40 item number 40. That's why I have mentioned.
So if 40 lawyers come from Delhi,
Yes, ma'am.
then are we required to hear all the 40 lawyers, ignoring the matters of the lawyers who are from Cuttack?
After lunch,
After we don't know. Wait.
Only prayer, ma'am.
Sorry. Is he a senior counsel?
Yes.
Is he a senior counsel? Is he a designated senior counsel?
No. Did you?
What kind of mentioning is this?
No.
Please don't do it again.
Yes.
Item 19 का परमिटेड उड्डयन माइला item 19 परमिटेड उड्डयन
Withdraw. Please दीजिए, we'll see what can be done. और ऐसी भाषा कभी नहीं बोलेंगे। Yes.
Yes, admission item number 1.
May I please your lordships? My lord, in this matter, my lord,
Before we take up this matter,
yes, my lord.
yes, what happened to that the medical students matter? Where is your item list, case listed? Where is your case listed?
Number 2.
Item number 2 we'll take up first. So whether you have got the online thing,
They have sent me a mail
link
intimating me about the date of the classes and all.
and link you have
Link also they have sent me.
So no further order is required to be passed.
My lord, your lordship, my lord, so far as the punishment is concerned, my lord.
File an affidavit. No punishment we will not.
My lord,
We will see punishment.
yes, let them file an affidavit, my lord.
You file an affidavit. File an affidavit. File an affidavit, and please tell your principal or vice chancellor, whosoever is there, that they are children.
Right.
They are children of their institution. So he has to, the vice chancellor, even if they have, according to the vice chancellor, they have committed some mistake.
But
If
let
possible,
them approach the vice chancellor.
they will approach, file your affidavit. We may pass an order for asking them to approach the vice chancellor. But please be,
Affidavit is ready. Your lordship may permit to file.
file
today.
it tomorrow. We will take up the matter tomorrow. Then tomorrow. File affidavit. File it today. File the affidavit today.
Yes, not ready. I will file.
File it. Tomorrow we'll record.
File
All
it
right.
today so that it can come on record. Do it fast.
Extremely.
Item 1.
May I please, your lordship? My lord, item 1, today the Director General of Police has filed an affidavit regarding the rescue of 5 missing children. And regarding the child who was missing from Utkal Balasram Katak, he has been rescued, my lord. On 23rd of May, he was rescued. He was produced before this honorable court. His medical assessment was done. And I think the medical assessment report is before your lordship in a sealed cover. He was, and now, my lord, we have he is also present in court with his father. His father has taken his custody, and the collector has also taken steps to see that he.
Ask, don't chamber. Come at, bring him at 1:30 in the chambers. 1:15. 1:15 in the chambers, and never bring those unless directed in the court.
Yes, probably.
All right.
ଖାଇବା ପିଇବା କଣ ଦେଇଥିବେ ଛୁଆଟାକୁ ହେଲା 1:15 ବେଳେ ଆମେ ଶୁଣିବୁ.
He is very smart. He will say everything.
Bring him.
Child after all circumstances. You interacted with
He's actually become a major in the meantime. He's 19 years old, but he's because of malnutrition, probably he's looking like that.
We will see.
Yes,
We have produced papers before the honorable
I know.
I know. That's
We know that. We know.
1:15 I'll produce it.
1:15 in chambers.
Yes.
And where is he right now?
He's with his father. Father is there.
All of them.
Yes, father is there.
He has been at his village since the last order of the honorable court. He has been with his father at his village.
Bring.
Last night we had brought him from his village only.
Bring him in the chambers.
My lord.
And unless specifically directed, the children should not be brought to.
No, from today, as a lordship will direct, he will not be present. He will go with his father.
No, henceforth.
Henceforth, unless, yes.
These children should not be.
Yes, obliged.
His parents are there probably. Only father or mother also?
Mother has expired.
Okay.
And that is
Oh,
one.
she's
That
a
is one of the
officer.
reasons why he.
All right.
And 1:15.
Item number 3.
Item 3. Here the delay has been condoned. The Honorable Single Judge disposed of the writ application, keeping in view that Patita Pavan Dattadas judgment. So there are interim orders operating of this Honorable Court. Lordship. Sorry.
No, but what is wrong with Patit Bhavan? What is this case about? These are. Oh, in these cases, the delay has been condoned.
Yes, ma'am.
In all the cases, the delays have been condoned.
Condoned.
We can hear it on merit. Where is the order? Impugned? 9/9/2021. No. 9/9/2021. This is the impugned order.
That impugned order.
Where is Mr. Sethi? It's also appears to be a batch. Separated, segregated within an order. 5 years. 2 years.
WPC number 19951 is that. Patita Pavan.
Patita Pavan Dattadas, that matter is sub judice before the on.
No, no. What is this? Which case is this? WPC number 19951 of 2020.
Patita Pavan Dattadas.
Patita Pavan. So why did you not file counter affidavit in this case?
Disposed of.
Was there any direction?
And, we had filed a counter affidavit that is at annexure 3, your lordship will find. Page 53. Petitioner was working as a sweeper on daily wage basis. However, he claimed for regularization of his service in terms of the government circular, that is 17/9/2013, which is basically in respect of the contractual appointees who were supposed to be regularized on completion of 6 years of successful completion of service as contractual. But the petitioner was a daily wager. And there was
So
no-
is this your case that it is not covered by the decision in case of Pavan Kumar Datta?
Patita Pavan
Patita
Datta.
Pavan Datta?
Mal. Because that is a case of data entry operators.
And posts were sanctioned in this case.
No, my. There is no sanction post. He was only given an appointment as a daily wager. That we had specifically stated in our counter affidavit.
All the cases are the same nature. How many cases are left? One.
These have been segregated from yesterday, there was some matters.
Where is it not? Stay. They're selling the impugned.
Order number 1.
Is there.
Item 3.
One.
Yes, sir.
So that's when was the delay condoned?
Delay, my lord, condoned on.
Yes, stay is already there. No, stay, yes, and we stay of the impugned. Final stay.
Your lordship, my the order dated 38/2022.
Yes.
The honorable court,
Is
since
your notice?
no delay has been pointed out by the office, the application is disposed of.
So this was.
If you notice. The requisites within 2 weeks.
My lord, notice has been issued on the same day,
Oh,
38/2022.
then someone to serve.
Yes, it. Yes, it.
No, he has appeared in the writ appeal. I was thinking he had appeared. in
Counsel
the
for respondent has already entered appearance. Somehow he is not present.
There is no representation on behalf of the respondent despite repeated calls. Unless this matter tomorrow under the same meeting, retain its position. We on the last date also, there was no representation on behalf of the respondent. No,
9/75/2024.
much. Yes, well,
Item 4.
Yeah.
Item for this is covered by my lord's order that for he has appeared. I will just give the copy, my lordship, one pass over. I am collecting that copy, my lord.
which judgment?
My lord's order, I will just give that order.
Laboratory technician.
Yes, ma'am. No, you have just remanded the matter to the honorable single judge because it has not been given opportunity for filing of counter.
That can be done.
You lost pass over one pass over. I am collecting that order so that it will be easier for
Similar
lords.
orders are there.
No, with the long, this is the order of the honorable justice Muralidharan. It's a long order. My lord's order is one page order. I will just
Let him give that out.
Let him then, and that is the, in fact, I had given,
yes, my lord has passed that order.
Now, this is the long order. Several petitions जो ଦେଇଥିଲି ଉପର ସେ What's the last part? I'm giving another one. This is the last one. This is madam. This is the one. Same thing. This is the last person. The matter was remanded.
they're doing. The state of Orissa has put to challenge an order passed by an order dated Nineteen 2022. 9/12/2022. Passed by a learned single judge of this court in WPC number 6131 of 2022. The said writ petition has been disposed of by the impugned order on the very first day when the matter was taken up on 9/12/2022 with a positive direction to extend the pensionary and other retirement benefits to the petitioner, to the respondent, in the light of decision of this court in case of Sarat Chandra Parida versus State of Odisha, 2015, bracketed 2 ILR Katak 94. So next it is submitted on behalf of the appellant that no opportunity was given to the estate to file an affidavit and put forth its case. So talk. Next, learned counsel appearing on behalf of the respondent does not dispute the
On the same date, the hearing was made and the application was made. Opportunity was there, but they didn't avail the opportunity. That is the difference.
learned counsel appearing on behalf of the respondent has submitted that though the state had the opportunity to seek adjournment for filing counter affidavit, but it is evident from the impugned order that no such opportunity was availed, and accordingly, there is no illegality in the impugned order. Now, what's up? Next. We have heard learned counsel for the, after having heard the submissions advanced on behalf of the parties, we are of the considered view that the writ petition could not have been disposed of on the very same day without giving the estate an opportunity to seek instructions and file counter affidavit. Oh, stop. Our attention has been drawn to a coordinate bench decision of this court in case of Damrudar Mahanta.
No, my lord, it is WA number 263 of 2020. Next page, my lord.
Next case.
Next page,
Next
WA number 263 of
All
2020.
right, all right. Case of State of Odisha and others versus
Vilas Chandra Jaina.
Vilas Chandra Jaina and another
Next
and-
versus Vilas.
batch.
Right.
Order dated लिख दिए
8/5/2020.
8/5/2023.
Right.
Whereby in similar circumstance, after setting aside the order passed by the learned single judge on the same day when the matter was listed, comma, the court remanded the matter back to the learned single judge for hearing of the writ petition on merits, paragraph 11. So this is only one case. No, stop. Accordingly, the appeal is allowed. The impugned order dated so and so. Intra-court appeal is allowed, and so is set aside. The matter is remanded back. WPC so and so is remitted back to the single judge to consequently let WPC number so and so be placed before appropriate assigned bench according to the roster for adjudication of the case on merits.
Item number 5.
This case, there was a direction to consider and dispose of the representation to be filed by the petitioner with regard to encroachment of government land by its a PIL millers. I talked to the officer that he as the collector, he directed the Tahsildar to inquire into the matter and do the needful. He says that within this week he will pass the final order. Lordship may call it on next Monday so that I can comply with Lordship's order.
As requested on behalf of the contemners, list this matter on 1 week to report compliance of this court's order, violation of which has been alleged in the present contempt application. Every time you are taking, without taking time, you are not disposing of the representations. At least now steps should have been taken.
No, now in view of that, the Chief Secretary after Lordship's.
And in fact, you will be getting the list of cases.
Friday list.
Yes,
Yes.
which shall be listed on Friday.
Friday, right.
So please ensure that
No,
And
I will collect it so that we
and-
can give prior information to the officer so that we.
not only that, you are required to file slips
No.
in such cases where the order has been complied.
Complied with, right.
Item number 6.
Next week, my lord.
Next date, 1 week.
God bless. Item 6 I have appeared. First one to lordship's notice have appeared. I want some time because I was told that some judgment have been passed by your lordships. And I also, there was some development in the meantime. That's a colleague, 1 week or 2 weeks after.
Letter of delay.
There was no delay because.
Delay.
Oh, so
it
that's
was-
what-
no
which
delay.
I
Ah,
guess
no,
was
officer
done.
pointed out that-
That I may kindly be.
Hmm?
That I may be disposed of.
Aye.
See the contradiction.
EA has not been disposed of.
That I for a condonation of delay my limitation. 1515/16.
As per SR, there
As
is no
per
delay.
SR, there is no delay, my lord. So that is not pressed also.
All right. EA number 7, so there may be no delay in filing of the present appeal. This application seeking condonation of delay stands disposed of.
We tell the order to continue.
Interim order. No, but what is the challenge? What is the matter about?
That the challenge that pending of disciplinary proceeding of for 4 years. Now the honorable single judge has allowed the writ application directly for consideration for sanction. In one case, I was told that the lordship passed an order judgment relying upon another judgment of court bench Justice Mr. Joseph's case. But this case little bit different, and there is some little bit development so far the disciplinary proceeding is concerned. So I want to take instructions so that lordship can discuss.
Senior counsel appearing on behalf of the contesting respondent seeks adjournment. Stop. List this matter on when?
2 weeks after.
2 weeks. The interim order shall continue in the meanwhile. Interim order is there? Yes. Let me add. Interim order is there.
Item number 7.
May I please, Your Lordship? Your Lordship, in this writ appeal, the appellant is partially challenging the order dated 30/5/2024 passed by the Honorable Single Judge, Your Lordship, wherein while deciding
Which annexure?
annexure 6, Your Lordship, the operative part is in page 44. Your Lordship, in this case, while the learned single judge was dealing with one case wherein 2 illegal documents were challenged, the learned single judge also called upon another matter relating to it. And without deciding the point of law on the basis of which an interim order was passed, the learned single judge was pleased to vacate the interim order, Your Lordship. Your Lordship, the brief fact of the case is that the petitioner, while working as an ASO, a government servant, he was convicted in a vigilance case while taking illegal gratification, Your Lordship. Thereafter, after conviction, he had challenged the conviction before this honorable court by filing a criminal appeal in which he was granted bail and the sentence was also stayed. And the conviction was, an LCR was called for the IA for considering the stay of conviction. Thereafter, Your Lordship, the department passed a notice proposing for dismissal of service. So the petitioner challenged the same before the then tribunal, Your Lordship. And the tribunal, after examining the facts on records, was of the opinion that there is a question of law involved, and until a counter is filed by the opposite parties, until then no final decision should be taken on the basis of the notice. Thereafter, Your Lordship, the petitioner approached this honorable court for the payment of unutilized leave salary, Your Lordship, which was granted by this honorable court. Whenever the petitioner approached the department for the payment of the unutilized leave salary, out of nowhere they suddenly passed an order giving no regard to the stay that was granted by the tribunal and then subsequently by this honorable court, and they passed an order for recovery of pension and stoppage of pension since the petitioner had retired in the meantime, Your Lordship. Particularly to frustrate the order of this honorable court, wherein the honorable court has passed an order to pay the unutilized leave salary, Your Lordship. Thereafter, the petitioner challenged those orders, Your Lordship, in which the orders which were passed, even if there was a stay order. And while the matter was being decided by the Honorable Single Judge, the single judge was pleased to quash the orders, admitting that the orders were passed, even if a particular direction was given in the interim order that no final order has to be passed. He quashed those orders, but also called for the case that was pending before the tribunal and then subsequently this honorable court. And even if no counter was filed, even if the case, the point of law was not decided, this honorable court vacated the stay while passing this order. Your Lordship, I have two contentions to make, Your Lordship.
What contention?
Your Lordship, while passing the order, the question of law that was involved, it
See,
was
somehow or the other, you could avoid the order of dismissal which ought to have been passed, which could not be passed because of some interim order passed earlier by the tribunal and subsequently by this court. So you should have been dismissed on the very day when you were convicted, because conviction was never stayed. All right, sentence was stayed, you were granted bail, but the conviction was there. And was it safe for the department to keep you once a criminal court held you guilty of accepting graft, taking graft? So therefore, it's a different matter that the order of dismissal could not be passed for some reason before you attained the age of superannuation. Now what do you want? How we do not find any.
Your Lordship, the reason why an interim order was passed, Your Lordship, is because even if there was no stay on the conviction, Your Lordship, the facts of the case were such that it was under active consideration, Your Lordship.
No active consideration. Law is very clear that once you are convicted by a criminal court, the action may be taken against you. And conviction, it's very difficult to stay conviction even by the High Court.
Yes, Your Lordship, but wherever the High Court decided the other two interim applications, Your Lordship,
So you should be happy about the fact that you were not dismissed.
Your Lordship, subsequently they passed an order for stoppage of pension and also recovery for pension, Your Lordship.
That you can challenge.
Your Lordship, that was passed in violation of the order of this honorable court.
All right. So have you challenged those orders?
Yes, Your Lordship. That was challenged in these two writ petitions itself, Your Lordship.
No. You challenged show cause notice.
I challenged the show cause notice in one writ petition, Your Lordship.
Yes.
Thereafter, in 2024, when the order was passed,
Presently, we are taking up this matter.
both of them were disposed of by a common order, Your Lordship.
All right.
By a common order. However, Your Lordship, the fact of the case is that when the complainant, Your Lordship, who had complained about the petitioner demanding for illegal gratification.
We are forming an opinion that the Central Administrative Tribunal was rightly abolished.
But thereafter, Your Lordship, this honorable court was also pleased to grant time to the opposite parties to file a counter, Your Lordship. It was only after the department passed.
It is because of the interim order passed by the tribunal that constitutional requirement under Article 311(2) could not be satisfied.
Your Lordship, only after
Where was the question of stay? When the Constitution clearly says that power is there with the government. How once the order of conviction, the judgment of conviction was recorded, could the Central Administrative, the Odisha Administrative Tribunal have gone into the correctness of the finding?
No, Your Lordship. The only question of law was that whenever the stay is still under consideration.
That is another question. That is another question.
Yes, Your Lordship.
But the question is the manner in which the tribunal stayed. That is not the question which is to be decided by us in the present proceeding. But this is the second case which where we are saying that similar interim order was passed by the tribunal, and because of that, no order of dismissal could be passed.
So that the interim order was passed appreciating the facts of the case, Your Lordship.
All right.
Your Lordship, my contention is that whenever the point of law was not decided and only a time was granted to the opposite parties to file a counter, Neither did they file a counter nor they filed an application for
Maybe-
vacating the stay, Your
Maybe
Lordship.
there was no question of passing of interest. That was thoroughly illegal order. And then you have been given relief. The appellant has put to challenge.
Another thing, madam, when the interim order was passed by the tribunal, it was specifically stated that till June 2018, final order shall not be passed. Thereafter, this court has adjourned the matter in 2024. Interim order has not been extended. Those two orders were they passed before June 2018?
No, Your Lordship, in the interim order, it was mentioned that it should not be, a final order should not be passed until the counter is filed. Counter or instructions are filed. And the counters have till date, I mean, it was not filed until it was dismissed also. Neither an application was
To
filed
file
for
the
vacation.
counter instruction in the last week of June 2018. So that means it is till June 2018.
Thereafter, Your Lordship,
This
till,
case in the last week of June 2018.
no, Your
Somehow-
Lordship, page 29.
No, page 29, yes. List
See-
this case in the last week of June
You read it.
2018.
Till then, final order in pursuance to Annexure 2 shall not be passed if the same has not been passed as on today till filing of the counter instruction. Your Lordship, it was until filing of the counter, and the counter was never filed, nor an application was filed.
What happened in June 2018?
Your Lordship, the matter was not listed. And thereafter, again, time was taken before this honorable court also. 4 weeks time was
You
granted
got
to
relief
file
for some
counter.
particular time, that can't be perpetuity, it can't continue like
You
that.
got more than what you were entitled to because of the lapses on the part of the,
Indeed, Your Lordship, they could have.
and to some extent, and to a great extent, because of the illegal interim order passed by the tribunal. Initially, I was of the view that the tribunal ought to have continued, but the kind of orders which we are seeing, is rightly abolished.
Whenever
The state of Odisha cannot have a different law than the other states of the country. The order of dismissal cannot be a state, and the disciplinary authority can never be asked not to pass any order. And so thus, see the kind of interim order which was passed, and you have benefited out of that. We do not find any illegality. This intra-court appeal has been referred against an order dated 35/2024. Yes, common judgment and order dated 35/2024 in WPC number 13523 of 2024 and WPC OA number 1114 of 2018. So stop. Next. Certain facts are not in dispute. So stop. The appellant was convicted of offense punishable under section 7,
13,
under section
13
13.
1D.
Huh?
13 1D and section 7.
13(1)(a) and section 7 of
Prevention.
the Prevention of Corruption Act,
13(1)(d)
1D.
1D
in section 7.
of in a trial arising out of Bhubaneswar Vigilance PS case number 7 on the allegation of having accepted bribe. So stop. At the relevant point of time, the appellant was working as, what is ASO?
ASO under Ayush Department, Your Lordship.
What is ASO?
Assistant Section Officer.
Assistant Section Officer. So stop. A notice was issued to the petitioner by the disciplinary authority for taking an action for imposition of punishment of dismissal from service, invoking Rule 19 of the 18, sorry,
18.
Rule 18 of Odisha Service Rules Act. What is the name?
Civil service.
And
CCA rules.
and Article 311 bracketed 2 of the Constitution of India. Stop. The appellant had approached the Odisha Administrative Tribunal, putting to challenge the said so-called notice dated 9/4/2018. First off, the Odisha Administrative Tribunal, by an interim order dated 18/5/2018, restrained the disciplinary authority from passing a final order. So stop. Upon abolition of the Odisha Administrative Tribunal, the क्या लिखा है? उसके पहले उसके बाद Tribunal, by filing an original application giving rise to OA number
111
WPC OA number 1114 of 2018.
1114 of 2018. So stop. Upon abolition of the Odisha Administrative Tribunal, the said OA number 1114 of 2018 is to transfer to this court and came to be registered as WPC OA number 1114 of 2018. So stop. During the pendency of the said WPC OA number 1114 of 2018, the competent authority passed orders on 3/5/2024 and 6/5/2024 for recalling the orders whereby the provisional pension sanction in favor of the petitioner, the appellant, while order dated 23/11/2021 was granted. First off, a decision was taken to recover the original pension amount to the appellant to the tune of rupees 20,08,553 for the period ranging from 1/6/2020 to 34/2020. First off, इसके ऊपर लिखा है, the came to be registered at so and so, यहाँ लिखा है WPC number. During the pendency of, when did you attain the age of superannuation?
Your Lordship,
20.
31/7/2020.
Meanwhile, the appellant attained the age of superannuation on 31/5/2020.
31/7/2020, Your Lordship.
No, 31/5/2020. Because you are granted provisional pension from 1/6/2020.
Yes, Your Lordship, 31/5.
31/5/2020. Stop. The appellant challenged the said orders dated 3/5/2021 2024 and 6/5/2024 by filing a writ petition under Article 226 of the Constitution of India, giving rise to WPC number 13523 of 2024. First off, both the cases were heard together, in the aforesaid background by the learned single judge who passed a common judgment, a common order dated 35/2024, which is under challenge in the present inter-court appeal. First off, learned single judge, after having noticed that the orders which were impugned in WPC number 13523 of 2023 were passed during the currency of
2024, Your Lordship.
2024. 13523 of 2024. During the currency of the interim order passed in the original application, interfered with the said order, said order. However, while quashing the said orders, the court, taking into account the fact that the appellant was convicted by a competent court of law and the order of conviction had not been stayed by this court, the learned single judge recorded that there was no irregularity on the part of the disciplinary authority in issuing the so-called notice on 9/4/2018. First off, accordingly, the learned single judge declined to interfere with the so-called notice dated 9/4/2018. First off, learned counsel appearing on behalf of the 2018. The learned single judge, while holding as above, observed that if the appellant has observed that if the appellant does not file a reply to the so-called within 2 weeks, it will be open for the disciplinary authority to take up the issue and pass appropriate orders. Next, learned counsel appearing on behalf of the appellant, assailing the impugned order, has submitted that the criminal appeal preferred against the judgment of conviction passed by the learned trial court is still pending, and an application for stay of conviction has also been that the issue of stay of conviction is still under consideration, and therefore, the single judge ought not to have vacated the interim order passed on 18/5/2018 in WPC bracketed OA number 1114 of 2018. Stop. Next, we are not convinced with the submissions advanced on behalf of the appellant as noted above. Stop. Learned single judge has rightly taken note of the fact that during the subsistence of the interim order, the respondents, the disciplinary authority / respondents could not have passed any order based on the conviction of the appellant in a criminal case. Stop. In the facts and circumstances of the case, the single judge has rightly vacated the interim order passed by the Odisha Administrative Tribunal, giving thus liberty to the disciplinary authority to take action in accordance with the provisions under Rule 19 of so and so rules and Article 311 bracketed 2 of the Constitution of India. Stop. We do not find any merit situated. Thus, we do not find any merit in this appeal, which is accordingly dismissed.
Item number 8.
Thanks, Your Lordship.
Order.
This matter drew the attention of your lordships couple of times. Couple of occasions, this matter drew the attention of your lordships court that in Balangir, a sealing proceeding was initiated under the Orissa Land Reforms Act for 696 acres. And the Land Reforms Authority has excluded 474 acres of land on the ground that they are in urban area. Although the law is that in urban area, even if the land is there, if unless they are meant for agricultural purpose.
No, but who are you?
But I am an activist.
You are an activist.
I have given the details of about my career in paragraphs 4 and 5.
All right, but whether any provision of law has been violated?
Yes.
Because
Clear violation.
Which-
Clear violation, 500 acres of land where a person is entitled to hold 10 standard acres. If a family in maximum 18 standard acres. But how in the impugned order, they have given them more than 500 acres.
when was the order passed?
The order was passed, but the question is this was in (2018), they have excluded these lands, and still the matter is pending for distribution and all those things. But the issue which I have raised is a proceeding under the scheme of the Act. A proceeding will be initiated on the basis of a draft statement, and that will be made final after the objections and other things. And after the final statement, sealing proceeding will be determined. In the instant case, the draft statement is missing from the record. So when there is basic document, which is a draft statement, which is missing from the record, how there can be determination? Then on the last occasion, your lordships were of the view that it is the state who can file an appeal or revision before the Board of Revenue. for revising this order. For that, I took time to find out whether such a step was taken or not. Because of the political elections and other things, the matter was delayed. And if the Lordship will grant me for some more time, I will find out what has happened there. Or the state can also.
No, but please examine whether we should entertain this.
After so many years.
All right. We'll. Can we entertain such PILs?
So because of the long delay and that too, after so many years, he has come before Lordship. He could have raised this question before the Board of Revenue and Revenue authorities also, my lords.
No, he may have a case.
No.
Suppose he does not know, and some gross illegality has been committed,
No.
and that information becomes public later. If the illegality is of gross nature, that can be brought to the notice of the court. This is
Right.
one aspect.
Right, no.
And the other aspect is that after all, we are bound by the procedure,
Right.
law, it's a self-contained code. So whosoever is aggrieved can approach appropriate.
Yeah.
Sealing matters, it is very difficult for this court to decide in
Exactly.
public interest litigation. It's very difficult.
Your Lordships on the last occasion have in fact observed that such type of scams are going on in different states.
Yes.
And therefore, it is necessary for the state to file an appeal or whatever the steps they are required to take. But after all, the public, the beneficiaries cannot be deprived of so much of land in the city itself.
No, but question, deprivation of the beneficiary is once it is decided that these are the sealing surplus lands. Unless there is a finding by the Tahsildar, the so much of land is sealing surplus. How can the beneficiaries will come into picture?
So again, the question is, Mr. Rao, can we go into a roving inquiry like this PIL? Reconsider if you want to.
Lakshmi, call it some other day, I will find out.
As a
Because of
requested on behalf of.
doesn't change it.
Let us see. But you just guide us whether in such cases the court should take up the matters or not. The state may take up, not, don't know, but prima facie I have my doubts. Though despite I strongly feel, speaking for myself, that land reforms laws have not been duly implemented throughout the country. Barring few, I don't know, but still we have to find our own limitations while interfering with.
That I can understand, my lord, but there is been a shocking illegality. And in this town itself, somebody owns land of 500 acres worth 5,000 crores.
All
by one family.
as requested, 8 weeks. Yes,
Item 9.
I was calling after 8 weeks.
8 weeks.
Item 9.
Let here the impugned order is an annexure 1. The decision of the State Sentence Review Board rejected the proposal for premature release of the petitioner, which is challenged in the state application. The ground Millard stated the relevant portion of the impugned order is at page 22. At serial number 33, the observation of rejection has been given. Committed rape and murder of a 5-year-old child and his death sentence has been commuted to life imprisonment. Therefore, rejected as per 6(1)(a) and (c) of the Odisha Gazette notification number 1174 dated 19/4/2022. Well, now the question, Millard, which is decided by your lordships and the points raised by the petitioner here. Whose policy decision would be applicable to the present petitioner's
Which?
case?
which policy is applicable to the present petitioner's case, whether the policy of the state which was prevalent on the date of his conviction, or the policy which has been framed subsequently. This honorable court has answered the said question in the case which I have annexed by annexure 6.
And where is that judge? That this has been conclusively decided by the Supreme Court in case of that Hari
Yes.
Haran.
Yes, that has been also referred to by my lord.
This is based on that judgment. only.
Yes, ma'am. My Lord
Then-
Justice Tarpatra and my Lord Justice Pratham have decided the point. The policy which is prevalent on the date of conviction is the policy, my lord, is to be decided for premature release of a convict, my lord, not the policy subsequent there. Well, here what happened in the year 2002 factor, this case is like this, my lord. The present petitioner allegation against him, my lord, one FIR was lodged in the year 2002 under section 302, 376F and 201 of IPC, my lord. He faced trial, my lord, in the year 2003 and by
No, where do you have right to remission?
right to
Under
remission,
which
my
law?
lord, you let's see, kindly see the policy. I am showing now the my lord, policy of 2022, my lord, by referring which, my lord,
Whichever policy, where do you have right to be released before you serve the sentence?
that is there in the policy.
What is there?
They are saying that after serving 25 years of reincarnation, my lord,
Yes.
including remission, their premature release would be considered. 2022 policy says that. But 2005 policy says, my lord, after serving 20 years of reincarnation, my lord, including remission, my lord, his premature release would be considered by the state.
It's considered.
Yes, ma'am.
So the requirement is of consideration. You don't have any right to
No,
be
my
released.
lord, we don't have any right, my lord.
Then what?
My lord, I am not on that point of my right, my lord. My question here, my lord, whether that policy, my lord, by showing which they have rejected. the
Policy,
proposal.
we are saying that even if old policy is applied in your case
Yes, ma'am.
and they decide to reject your prayer for remission,
Yes.
then
They have, my lord, they have not decided on the basis of the earlier policy, my lord, of 2005, when the policy was in force, my lord, on the date of his conviction, my lord. Date of the policy which was held, my lord, which was there in the year 2005, it speaks, my lord. After putting 20 years of reincarnation, including remission, my lord, his very premature release would be considered.
no, but why has this come before the division bench?
Because, my lord, earlier also this division bench, my lord, this division bench of this honorable court, my lord, has
Earlier,
this.
you had come up earlier.
No, my lord, I have not come up earlier. Sir. I am relying upon a judgment of this honorable court, my lord,
No,
where you.
No, we were asking why before the division
My
bench.
lord, here, my lord, I have also come up earlier, my lord, by filing a WP CRL, my lord. I have also given reference to it.
Challenging rejection of the division.
No, but
No. What is the residuary?
residuary, but residuary division, residuary single. Probably because of.
We don't find anything.
There is some.
And you have remained in custody for how long?
My lord, now, my lord, including remission, my lord, more than 24 years.
Forget remission.
My lord, 21 years, almost 22 years.
Almost?
22 years, my lord. As on December 2023, my lord, my lord, the present petitioner was in custody. 21 year, 1 month and 8 days, man.
File your affidavit, Mr.
Yes, I'll file that.
6 weeks time is allowed for the estate. Have you served copy?
Yes.
One copy my friend has given. He may give me one more copy so that I can.
Let one more copy of the writ petition be served upon an AGA in course of the day. Stop. By
Today.
course of the day. Stop. List this matter on 6 weeks so as to enable an AGA to seek instructions and file counter affidavit. So his simple point is
Yes, please.
that his case ought to have been considered under the
2005 rule. Yes.
5
It
policy.
is.
So even under 2005 policy, you could have rejected.
Yes.
But you should have mentioned that here.
Instead of
This is-
2005 to 2022, it says it's not non-application of binder. That is the only question. I'll understand that.
Item number 10.
The petitioner had taken admission in BSc optometry course in 2020, my lord. And in the meantime, she has completed her course, but he has not appeared in examination. The university not conducting any examination till yet, my lord.
Which course?
University, my lord.
Which
Optometry.
In course BSc in optometry,
Optometrics,
my lord.
optometry.
Optometry, my lord.
We were admitted when?
2020, 2021.
By which university?
Sri University. Under Maharaj Sri Ramchandra Bhansadev University.
Hmm?
Under Maharaj Sri Ramchandra Bhansadev University, Sri Ramchandra Vihar, Takatpur, Baripata.
Is it a private university or
My lord.
it's a private university?
No, my lord.
This is that the university is of the state recognized. That
Then why
is,
are you not holding examination?
no, my lord, I am not the university council. I am for the DABT. We have given them NOC and we have given them provisional recognition. They have taken admission. They have to get affiliation from the university for appearing in the examinations. The university has done what just now he has given me a copy. So the question lies with the university why they have not given them chances to appear in the examination. We have from our side, we are clear on in our official orders.
So you are a student,
Students,
and where is your institution? Which institution is this?
institution is OP number 4, OP number 3,
Name 4.
4.
So whether the institution has been affiliated?
My lord.
Affiliated, where have you stated? Which date? Where is your date chart? No date chart. NOC we
Para
find
9. Para 9 I have stated.
Para 9.
Page 5.
It is stated in the. But the course was for what period?
4 years.
4 years course. BSc.
It is the petitioner has alleged in the present writ application that he is a student of which college? Which college?
4 my lord. Biju Patnaik Medical Technology.
Biju Patnaik
Medical Technology.
Medical Technology,
That is the college.
My lord.
At the college.
which is a private recognized institution and has been affiliated by Maharaja Sri Ramchandra Bhanjan Rao Dev University, Sri Ramchandra Vihar, Takatpur, Baripada. So he is pursuing 4-year course of no examination has been taken.
No, it is.
Then why are you coming now? You were admitted in 2020, first semester was not held, second semester was not held, and you are coming in 2024. What is your explanation?
23-24 session has been given final recognition, but yours is still there. Annex
My lord,
5,
page
19.
26, the temporary affiliation is given by the university, page 23, 26. Or 21, 22, 20, 23.
4-year course of
Optometry.
optometry, but BSc in optometry. But the university is not holding examination. But the others must have been allowed to participate.
No, in the student of that college. No,
But the students of other colleges must have been allowed.
University can also, and a university can say.
You have been temporary affiliation, you in 23, you have been granted for 2021.
Yes.
That is no examinations for
Yes.
before that.
Yes. That's what pays 26.
But what is the meaning of this granting for previous sessions? You're granting affiliation.
No, they should give the affiliate,
Before that.
NOC we have given them in time.
There.
For provisional recognition we have given in time. They have taken admission. They should get the affiliation from the university. Affiliation university is not given.
You should notice the grievance of the petitioner is that he is not being allowed to appear in the semester examinations which are being held by the university. Stop. You should notice, Mr. She is not. She will be she. You accept notice on behalf of?
A DMET, OP number 2.
That's also accept notice on behalf of OP number 2. OP number 1?
State government.
And Mr. also on behalf of OP number 1, then OP number 2. Issue notice OP numbers
3 and 4.
3,
and
3,
4.
3 if it's government.
Three is, they have the quarter panel.
Okay.
3 and 4. Yes.
Lord, let the learned petitioner implead the Odisha University of Health Sciences, because initially it was by Maharaja Bhanjadev, then subsequently under one umbrella they have put all the health, the institutions imparting health education, but they have put under one university, that is Odisha University of Health Sciences.
Which
That is page 28, Your Lordship.
no, which whether they have been implemented as party or not?
No.
Not
They are not
implemented. That is what I am saying. Let
It should implement as a party and notice should go to them.
Counsel for the on oral submission made on behalf of the petitioner. Let Odisha
University of Health Sciences,
Health
Bhubaneswar.
Sciences is permitted to be treated as opposite party number 6, 5. 5. Let it be done in course of the day. Issue notice 3, 4 and 5. 3 and 5, not 4.
4 also notice has to go.
3,
to the
4 and
college.
5, all right. 3, 4 and
The
5.
college.
3, 4. Yes, 8 weeks. 1 week for requisites, 8 weeks.
Item 11.
11 is same law, but 4 is BSc in medical radiation and technology.
Same year.
My law.
Here also he has to make health university as a party.
Same order. Course change karo. Yes.
Item 12.
My lord, petitioner institution, my lord, had applied a lot of NOC. Petitioner, my lord, the petitioner challenging the Annex 7, page 57.
This is for what? The lecture?
Annex 7.
7, what is there?
My lord, earlier the petitioner had applied for a renewal of NOC for the 9 courses.
So
my
that
lord.
session is over, sir.
Yes.
My lord.
Learned counsel for the, it is written from the materials on record that the relief that the presented application has become infructuous with the lapse of time. The application stands disposed of accordingly.
Item 13.
My lord, this PIL pertains to the physical punishment being inflicted in schools in violation of section 17 of the Right of Children to Free and Compulsory Education Act 2009. And what prompted the filing of this PIL is the death of a class 4 student, a 10-year-old student in a government UP school after undergoing physical punishment. And the petitioner has cited other cases also of physical punishment.
So what direction should we issue?
For direction of enforcement of section 17 of the Right to Free and Compulsory Education Act in letter and spirit, with a view to protecting children from physical punishment and mental harassment in schools throughout the state, to take appropriate action against the teachers found guilty under section 17(2) of the aforesaid act, to arrange training and sensitization programs for teachers regarding physical punishment and mental harassment of children in schools. I have also met the parents of the deceased child, my lord. They have not been given any compensation or ex gratia. And I have espoused their cause in this petition also to pay compensation of rupees 10 lakh to the parents of the deceased child, my lord. These prayers are made.
Let them come.
My lord, I am in touch with them. I have met them. They will become interveners. My lord, they will also become interveners in this
Not
case.
for we can sense the background in which the writ application has been filed. It's a different matter that the statutory provisions are required to be implemented
Yes.
in the later and spirit.
Yes, my lord.
But the moment you raise the question of compensation, you
My lord,
don't do that.
My lord, kindly bear with me. In Chandrima Das case, the Honorable Supreme Court has
Mr.
also.
Counsel, you have a wakalatnama from them. It's an individual matter, payment of compensation, let them come.
My
But
lord, they will become interveners in this case, my lord. They will become interveners in this case, my lord.
Why?
Because I have met them, my lord.
Why did you meet them?
Met them as a human rights activist.
You are a human rights activist?
Yes, advocate and human rights activist, my lord. And I have filed such PILs for payment of compensation in this honorable court. And
that creates that raises doubt.
No, my lord, I have to prove my credentials in the first case.
You cannot prove your credentials.
Yes, my
the
lord.
moment you raise a question of payment of compensation, you lose your credential.
My lord, my lord, kindly bear with me. Kindly bear with me.
Since you are a counsel, you can file an application for them for payment of compensation with their wakalatnama. Why does it have to be a PIL?
My PIL,
Why have you come
larger
to
issue, my lord.
Why have you come?
I have filed a larger issue citing these instances.
So don't raise that issue. Payment of compensation, the moment you raise that issue, we will dismiss it.
Okay.
Larger issue, yes, we are there.
Yes, for larger issue, my lord, this PIL may kindly be. My lord, this case may be taken up tomorrow so that I can cite the Chandrima Das case and also other cases regarding.
You are
payment.
not required to cite Chandrima Das. All right. You are not required. Chandrima Das judgment, you are not required to cite before this court.
My lord. My lord, this honorable High Court has also awarded compensation in many PILs.
This application is dismissed.
No, my lord, kindly bear with me.
Sorry.
No, my lord, I am bowing down. I am bowing down. I am not pressing that compensation issue. I am bowing down.
Sorry.
I am bowing down, madam. Bowing down, keeping the larger issue of children undergoing physical punishment in schools. This PIL may be kindly be admitted, except the issue of compensation.
File a memo
I will file a memo.
that you don't want to press those.
Okay, my lord, I will file a memo.
You said because of your illness, you have joined online.
Yes, madam.
So are you unwell?
No, my lord, I'm ready to give them.
All.
My lord, this opposite party number 3 is an Apex Cooperative Society registered under the Orissa Cooperative Society Act 1962. and that registration of certificate has been granted in favor of the opposite party number 3 by the opposite party number 2, who is the registrar of cooperative societies, and under section 3 of the OCS Act.
You have filed this PIL.
Yes, my lord. My lord, on account of assumption of charge by the opposite party number 2 as the managing director of opposite party number 3, there is creating a vacuum in a revisional forum as well as a dispute deciding forum on section 70 as well as on section 112 of the OCS Act 1962.
The state cooperative.
Yes, state.
Where in the premises of issue of
This is the case in which writ of quo warranto was issued.
Yes, that is lordship will dispose of because they took a decision that they will be appointing the new MD in due process. Lordship will dispose of because the old who was continuing after retirement, he has been.
But the selection process has begun, Mr. Counsel.
Yes.
They are going to appoint.
On 10th June 2024, the opposite party number 2 has unilaterally assumed the charge as the managing director, which has created a vacuum and revisional forum on section 112 as a revisional authority.
So opposite party number 2 should not function.
Yes, madam.
Then the vacuum will be will no more be there.
Yes, madam. That is my whole humble submission.
And vacuum will be there. Nobody will function.
What's the meaning of vacuum?
That has happened, madam. And because he cannot be the judge of his own cause, because he is in case of filing a dispute on section 68 before him.
You are right. Right, but they are taking a
By
step.
order of the court, he is functioning. The register.
And since 2023, February 23, when the order was passed,
But what about steps for appointing a permanent managing
that the
director?
managing committee will take note because they gave an undertaking before lordships that they will do it soon. So in view of that, I don't think he is a case. Your lordship, only last week your lordship disposed of that writ application.
All right. What order do you want us to issue?
In place of opposite party number 2, any other officer in the office of opposite party number 1, he may continue till an appointment is taken up by the opposite party number 4.
Any officer means subordinate to that registrar?
No, madam.
Who else?
Any officer in the rank of IAS in the office of opposite party number 1, in the cadre of IAS, other than the opposite party number 2.
No, but we will have to set aside the order of this court by which registrar is functioning.
Yes, ma'am.
16 to 2000.
Do you understand? There's an order of the High Court way back in 2023. Removing-
That is under Annexure 1, madam.
Yes, so if that order stands,
My lord, but there, my lord, have already taken categorically held that the action of opposite party number steps of opposite party number 4, that is contrary to section 28(3)(b)(1), and since then no spontaneous steps has been taken, and in the meanwhile 2 revision applications have been filed, but the registrar has failed to pass any order because of this his appointment assumption of charge as the managing director.
Your Lordship, on 13/9/2023, the order passed on 16/2/23 was modified to the extent that, having heard if I read out annex page 17, Your Lordship, the order is given that this, having heard learned parties, but however, without expressing any opinion on the validity of the appointment of the managing director of Odisha State Cooperative Bank, this court modifies paragraph 10 of the order dated 16/2/23 to the extent that, as opposite party number 9 has already handed over the charge to the Registrar of Cooperative Societies, Odisha, and the post of Managing Director, Odisha Cooperative Bank is lying vacant. If the opposite party authority appoints anybody as Managing Director, Odisha State Cooperative Bank, the same shall be subject to the approval of the Reserve Bank of India.
so much water has flown since then. They are again appointed that same person.
Yes, Your Lordship.
That petition is over.
Yes.
So now again the same position.
Yes, Your Lordship. But he is with this order, Your Lordship. He has come with this order. So I think he's not aware of the last order that has been passed by this honorable court.
Well, let us see. File an affidavit. In fact, you appointed someone,
Yes, sir.
A, and that order was passed. His appointment was held to be illegal.
Same.
Then you appointed the same person again. That was stayed. And that writ petition has been disposed of in view of your stand that he'll no more be appointed. Now, because you could not appoint him, you are not ready to appoint any other person. Clear.
Mr.
On
Tripathi.
16/2/23, Your Lordship, this Honorable Coordinate Bench had ordered that for the Register of the Societies to take
That
the
is what I'm
charge.
saying.
He's functioning.
Charge, but still his appointment, he is functioning,
Yes,
but
yes.
he is not functioning in accordance with law.
Right.
Again, in his case also, there was requirement of the approval of the Reserve Bank of India.
Who does anybody else?
Huh?
Here, this court has said that if the opposite party appoints anybody as managing director, same shall be subject to approval.
Law is law.
So that
Or
they are
requires
not carrying
approval.
out. They are happy
Yes,
to
Your
stay
Lordship,
like
we'll file an affidavit to the effect.
4
Your
weeks.
Lordship may notice the bank also, Your Lordship.
Issue notice to opposite party number.
Opposite
3
party
and
number
4.
3
3 and
3 and 4.
3 and 4.
3 and 4.
Issue notice opposite party number 4. Requisites 1 week, 8 weeks. In the meanwhile, so and so accepts notice on behalf of opposite parties number
1 and 2, Your Lordship.
1 and 2. Let affidavits be filed on behalf of the opposite parties by the next day, date. Stop. This case on 8 weeks.
Item 15.
Yes.
15.
Please to your Lordship Miller. This is a PIL mailer, petitioner.
IA for
IA must have
Stay.
been set for, no, must be for appointment or something else. Director, deputy one associate officer, preferably in the cadre of IAS. Final thing.
Yes.
Please to your Lordship Miller. This is a PIL mailer, the petitioner filed being authorized by the villagers of some villages in and around the Paiko Fort of Tapangor near Hatia Hill of Khorda district mailer. Due to the granite mafia mailer, due to blasting of the hills mailer, all the roads are covered with the stone and dust, and the buildings, the school buildings and colleges are destroyed. All the then, my lord, earlier the rectification also PL filed. Then you will also turn to page 26. The State Pollution Control Board earlier wrote a letter to the collector Khurda that saying that I'm reading, my lord, page 26, my lord.
All right, we will see.
Due to-
for file. 8 weeks time is allowed for the state to file counter affidavit. Who are the opposite parties?
All the opposite party are
1, 2, 3 and 4, Your Lordship.
4.
I went
And the
1, 2,
others
3
are-
and 4. I take notice on behalf of 1, 2, 3 and 4.
4. Technology on behalf of 1, 2, 3 and 4. Who are others opposite
But
parties?
the 5 is the administrator of Jagannath Temple Authority, and 6 is the State Pollution Control Board.
5 is party?
Because their land are there.
Land of Lord Jagannath, so that they have used. That are paid. After that, before auction, these land traders are dealing with that. Oh, you are saying the land has not been leased out, but illegally they are mining there.
Yes, my lord. And then also, my lord, the temple authority wrote to the Tahsildar to go and so that I made it party, my lord. Because their land is part of the hill, the land of the Jagannath Temple.
Yes or no?
Item 16.
Lordship's order has been complied with. For Lordship direction, pension has been sanctioned. I have given a copy to my friend.
I've received that letter which my learned friend has given us. Your Lordship may only observe that I'll be receiving this amount without prejudice. Without prejudice.
Uh,
Because the calculation may
Mr.
be. So they have said that the calculation is
Mr.
areas is.
Samurai, learned counsel appearing on behalf of the contemners has submitted that a revised pension payment order and revised gratuity payment order have been issued by the Office of the Controller and Accounts, Odisha, Bhubaneswar on
25/6.
25/6/2024. He submits that this court's order has thus been fully complied with, with the issuance of the payment orders. So stop. Next. Learned senior counsel appearing on behalf of the petitioner has submitted that the petitioner may have the liberty to examine the correctness of the amount determined by the opposite parties payable to the petitioner against a revised pension and gratuity, Stop. Considering subsequent conduct of the contemners, the contempt proceeding is dropped. Stop. The petitioner shall have liberty to question the correctness of the determination of the amount found payable to him.
Her.
To her.
No, him.
Him.
Because the family pension has also been calculated
In
for the
terms
wife.
of payable to him. To the petitioners.
Is Vishnupada Barik Millers.
Both the pension and the family pension.
The family pension nowadays they calculate it Millers. Immediately
Okay,
after that they
That
get
is why I
it.
got confused. Because family pension.
Yes.
Lordship may say that both the pension and the family pension.
The pension is automatic pension now.
Tell him. By the opposite part, by the contemners, which have been authorized for payment by the Office of Controllers application. All right.
Item 17.
Yes, my instruction is that the order of the lordship has already been complied with the help of police, encroachment has already been removed.
As stated by learned AGA appearing on behalf of the contemners, that the court's order has been fully complied with in as much as the encroachment in question has been removed.
Yes, encroachment has been removed.
This contempt application stands dropped. Contempt proceeding stands dropped.
Item 18.
Yes.
In item 18, I am appearing for the opposite party. The Lordship may see page 16, the order which is allegedly not complied by the opposite party. There is no direction at all. I am just placing the order of this on the court, which is available at page 16. Mr. Swanse, though the petitioners have challenged the order passed by the Commissioner PMC, Bhubaneswar on 23/6/22 under Annexure 5, however, during course of hearing, Mr. Swanse submits that liberty may be granted to the petitioner to file applications for grant of certificate of vending as envisaged under the State Vendors Act and the Odisha Street Vendors Protection Regulations. considering such submission, the writ petition is disposed of granting liberty to the petitioners to file individual applications for grant of certificate of vending as envisaged under the above provisions of law. So only the liberty.
Thereafter that order in first contempt.
So thereafter they filed contempt, first contempt and comply. There is nothing to comply. There was only a liberty. There was no direction in the order. So only they will submit the application. Liberty was given to them.
That is why he has not come.
That is perhaps that is why he has not come.
There is no representation on behalf of the petitioner. There is allegation of disobedience of this court's order dated 18/7/2022, passed in WPC number 16942 of 2022 in the present contempt application. Stop. Following is the operative person of the order dated 18/7/2022, paragraph 3. Stop. It is manifest from this court's order dated 18/7/2022 that there was no positive direction issued to the contemners which was required to be complied with. So stop. No case of disobedience of this court's order is made out in the present contempt application. This application is dismissed accordingly.
Item number 20. 19 Woodrun. Item 20.
That's an item number 20. The Lordship's order has already been fully complied with. Lordship's direction was to pay them the amount. Out of 12%, 10% have already been paid their amount, and 2% petitioners died. So they've been issued notice to give the details, and it will take around 1 month because they have to different account. That will pay. Lordship will dispose of, saying that rest too will do it in 4 weeks.
Where is the order?
Order is at
10.
Yeah. In fact, granting case where FAO was filed, FAO was dismissed. Thereafter, an order was passed. If you also look at page 12, the order, the division bench. Thereafter, Honorable Single Judge dismissed the FAO at page 16. Contempt order, page 22, there was an order of contempt. The WPC number 9189 of 2005 not yet been complied. So 2005 original order. That is at page 12, your lordship, 2005 order.
Condemnation of delay petition has been dismissed.
Yes. Now, because the FAO has been dismissed, we have to comply the order, execute the order of the Lord Tribunal, Education Tribunal. So that we have executed, made the payment.
Yes. Run counsel for the AGA representing the contemners has submitted with reference to the written instructions which he has received from the Office of the District Education Office, Balasore, that this court's order dated 25/9/2007.
Yes, ma'am. 2007.
Passed in WPC number 9189 of 2005. has been fully complied with. Full stop. Out of there were 12 petitioners.
12 petitioners. You also will find that the document I've given in next second page, 10% have been paid the amount and 2 persons have died. So notice has been issued to the legal heirs to submit the document so that they can be paid
He
the
has
amount.
submitted that 10 out of the 12 petitioners have been paid the amount which they are entitled to. Stop. The rest 2 died during the pendency of litigations before this court. Stop. Steps are being taken to ensure that the amount payable to the deceased employees are paid to their legal heirs. This is your submission.
Yes, sir.
Contempt Act application, there are 4 petitioners.
But
writ petition.
but the order is in respect of all 12 millers. So we have complied with 12 persons.
Petitioners. Oh, next. Learned counsel for the petitioner does not dispute this position. We do not find that any case of willful disobedience of this court's order is made out, considering the subsequent conduct of the contemners as noted above. Stop. The contempt proceeding stands stopped.
Item 21.
21, the lordship's order has already been complied with. I'm giving a copy of the speaking order to my friend Miras. Lordship may dispose of this.
Complied with.
For orders item 22.
Right, please, my lords. My lord, this is a matter wherein the OP number 2, regional control of mines, had, without giving an opportunity of hearing and without adhering to the 30 days period as mentioned in the MCDR rules, had forfeited the bank guarantee, financial assurance submitted by the petitioner. Page 182, Annexure 30 is the show cause notice. They granted 7 days time. We sought some more time. But page 15, Annexure 15, page 185 is the impugned orders, my lord. During the peak of COVID, they forfeited the bank guarantee by passing the impugned order, 31/3/2020.
The petitioner in the present writ application filed under Article 226 of the Constitution has put to challenge an order dated 31/3/2020 passed by the Regional Controller of Mines, Bhubaneswar.
Ministry of Mines, Bhubaneswar, my lords.
Ministry of Mines, Bhubaneswar. Full stop. by the said order, comma, in exercise of the power under Rule 27(3), read with Rule 3 bracketed C of the minor which page is that?
Page 185, my lords, the order, impugned order.
No.
157 would be, your lordship. That is Rule 27(5), Mineral Conservation and Development Rules.
Page 158,
2017.
my lords.
157, 158.
MCDR rules.
MCDR rules.
Mineral Conservation and Development Rules.
Yes.
My lords, 2017.
Yes.
Mineral Conservation and Development Rules, comma, 2017. As forfeited the financial assurance submitted to the office of the regional controller of amount of rupees so and so 30 crore.
3 crore,
3 crore
92,400.
issued by Yes Bank, Kolkata, has been forfeited under Rule 27(5) of the rules.
My lord.
Of the MCDR rules 2017. थोड़ा correction करना होगा मेरे सामने.
हाँ.
Just
Mm.
27(3) 27(5). By the impugned order, the regional controller has further directed that the said financial assurance should be realized and remitted to the government of Orissa. So stop. Next, assailing the impugned order, then counsel for the petitioner has drawn this court's attention. Where is the requirement of 30 days?
My lord,
Rule
27(5).
27(5).
27(4) and 27(5, both. 27(4), my lords. If the authorized officer, as the case may be, has
drawn
reasonable
our attention to the provision under sub-rule 4 of Rule 29 of the MCDR rules, which requires a lessee to be given a written notice of the authorized officer's intention for forfeiting the sum assured at least 30 days prior to the date of order to be issued. So stop. He has submitted that sub rule 5 requires that only in case a satisfactory reply is not received within 30 days of receipt of notice referred to under sub rule 4, comma, the authorized officer has jurisdiction to pass an order forfeiting the surety amount with a surety amount. Stop. He has submitted that in the present case, the notice was issued on 16/3/2020 as contemplated under sub rule 4 of rule 29 of the
Rule 27, my lord.
29 of the rule 27, sorry, rule 27 of the MCDR rules. Stop. The petitioner had sought for time to file,
Further
time to respond to the said notice. Stop. Disobeying the statutory mandate under sub rule 5 of rule 27, the authorized officer passed the order on
31/3/2020.
31/3/20.
Your mining lease was expiring on 31/3/2020.
My mining lease had already expired in 2013. In anticipation of being granted an extension, my lord, I had submitted this financial assurance. But no extension was granted later on.
As per records of this office, the mine was non-working and the mining lease will be expiring on 31/3/2020. That is there in the notice.
Had it been given an extension, but there was no extension given.
This is only a question of forfeiture.
My lords.
And they will consider. Correct. Pass the order on 31/3/2020, comma, much before expiry of the statutory period of 30 days. Stop. Next, despite opportunity granted to the opposite parties, no counter affidavit has been filed. Stop. After having perused the pleadings on record, we have heard. After having perused the pleadings on record and the documents including the notice issued under sub rule 4 of rule 27 of the MCDR rules and the order passed under sub rule 5 of rule 27 of the rules, we are convinced with the submission advanced on behalf of the petitioner. Stop. Sub rule 4 of rule 27 of the rules, MCDR rules, reads as under. Stop. Further, comma, sub rule 5 of the said rules reads as under. Stop. Apparently, the impugned order dated 31/3/2020 was passed. Apparently, the impugned order dated 31/3/2020 based on so-called notice issued on 6/3/2020 is not in conformity with the legal requirement under sub-rule 5 of Rule 27 of the MCDR rules. First of the impugned order dated so and so 31/3/2020 deserves to be set aside on this sole ground. First of the consequences of quashing off the order dated 31/3/2020 shall follow. First of, next, we make it clear that we have not gone into the gone into other aspects of the matter. First of, it will be open for the authorized officer to exercise his power under sub-rule 5 of Rule 27 of the rules in accordance with law. Its application 4 and 5 in accordance with law.
Well, diplomacy.
My lord, the
Lord, law-
submission of the bank may be recorded, my lord. On 1st of October 2020, we remitted the amount to the government.
We have mentioned, the council representing the Yes Bank has submitted that pursuant to the court's order dated, pursuant to the
Invocation of
order
the bank.
dated 31/3/2020, the amount
3
has
crore
been
92,400.
remitted
Yes.
to
Lord, the OP1 and 2, Lord, the Ministry of Mines.
to the Ministry of Mines, Odisha.
Yes, sir.
So be that as it may, consequence of this order shall follow. इसके ऊपर लिखो, यहाँ पे consequence. It will be open. So it is further observed that if the all right.
My lord, if the bank guarantee is returned, my lord, to the bank,
They may pass a fresh order, Mr.
my lord, the interest for the intervening 4 years, my lord, or else I may pray that it may be kept in a separate interest bearing FD, my lords.
No, they may pass an order.
My lords.
Little.
Whatever he wants. First till date he has not filed the proposal.
Now you can file your reply. That we can. We have not set aside the so-called notice.
No.
Then we can give you liberty.
My lords may direct that Shukar, if any fresh Shukar.
Where is the fresh so-called? The same so-called.
My lords.
So we further observe that it shall be opened for the petitioner to file his so-called reply before the so-called reply pursuant to the so-called notice dated 16/3/2020 within 15 days from today.
30 days, my lords, kindly 30 days.
You already got 15, now you got 4 years.
4 years, 15 days from today. Stop. If such a reply is filed to the said so-called notice, it will be open for the authorized officer to pass an order in accordance with law. We'll modify some part of the order.
I would also pray, my lords, the interest for the intervening 4 years, my lords.
Depend on what happens.
My lords.
That will depend.
And the amount can be given back to the bank.
Consequences we have mentioned. The whole problem is that everything will depend on final decision which is taken after you submit your reply.
My lord.
Item number 23.
You lost this pardon, Lord. I'm for the petitioner.
You're so happy.
My
you're
lord,
for the
I beg your
petitioner.
respect. Some time may be
Is this
given.
your first case, huh? In this case, my lord, state has filed an application for modification of the order, my lord. Pursuant to your lordship order dated 3/9/2021, my lord. The query has not yet been settled, my lord. Because the petitioner is the second highest bidder, my lord.
Yes.
The first highest bidder has already deposited declared as a successful bidder and deposited some amount, my lord. Thereafter, he disputed that the quantum of the calculation of that amount, and that was for the collector being the competent authority. In this moment, my lord, the petitioner has filed this application and interim order was passed, my lord. In view of interim order, my lord, the said query has not yet been settled since 2021, my lord. So when did you file the application?
We have filed application
The order of stay.
for 2022, madam. Flag B, madam.
For?
For 2022, madam.
You are seeking this.
For 2023, madam. 23.
Therefore, OP5.
Yes, OP5.
My lord. OP5 is the successful bidder.
It's not been issued. It should be directed. 17. File touch.
Yes.
I'm for the petitioner, my lord. I crave, Lord, some time may be given.
Lot of time was gone.
Any day next week. Then, my lord, I brought on. Then, my lord, for consideration of the present application, interim application, order of this honorable court dated 3/9/21 is important. While issuing notice, this honorable court has found that the opposite part number 4 and 5, they have flouted the condition of the notification of the tender. That has been crystal clear in para 3. Therefore, this honorable court.
No, that is an interim order. Finally, we have to decide whether that observation is correct or not also. That
Yes.
also.
But the interim order, if that interim application is prayer will be allowed, then my humble submission, this REIT application may be in progress because they will go ahead with the this honorable court restrained the OP number 5 to deposit the balance amount, which he didn't deposit in spite of several reminders issued by Tahsildar. OP4 Tahsildar, he has issued several reminders calling upon the OP number 5 to make deposit of the amount, but he didn't turn up.
Opposite 5 disputed the quantum of calculation. And that calculation that application was forwarded to the district authority for necessary clarification. That's why he did not deposit. And in the meanwhile, this honorable court passed the interim order.
My lord, this that.
So once this calculation is disposed of, everything will be clear, my lord.
Exactly. So have you, what is the correct calculation have you furnished?
My lord, he has also given that undertaking that whatever the amount will be deposited, will be calculated, he will deposit the amount.
They have not decided that what is the calculation.
Because in view of interim order, he is not able to deposit.
What is the interim order?
Interim order restraining OP number 4 Tahsildar to accept the balance amount.
Then how he will deposit?
Who is the OP number 5 was depositing in a piecemeal. First deposit some amount, then he made an application raising the point of calculation.
Where is that order?
Yes. My lord, that is order dated 3/9.
But do you do it without ascertaining the proper amount?
Yes.
Do you accept a bid? And then the person will dispute and you will grant.
No, my lord. He was declared as the successful bidder.
On what basis of what amount?
Taking into consideration of the offer is additional amount, my lord.
So how could he dispute it? When
No, my lord. He is disputing the quantum of calculation of the DMF. After declaration of successful bidder,
That
Be-
everybody can do, and you will
no,
grant
no,
time for that.
no, my lord, as because he has,
This case.
my lord, as because he has deposited some amount, and thereafter he disputed the amount. That application was forward
Where is the interim order?
3/9/2021, madam.
What is there?
My lord, the Tahsildar was restrained to accept the amount from the successful bidder, and so also the opposite five was restrained to
Where is that?
3/9/2021 in this case.
Which paragraph?
Well, that the interim order, madam.
But interim application, phase two, paragraph 4.
In the interim, my lord, the opposite party number 4, Tahsildar, Godamba District Court directed not to allow the opposite five to deposit the balance amount and to operate the sand sirer under the next one till the next.
Who is for the OP number 5?
Opposite party 5 with the successful bidder.
Where is
Not, he is not happy.
notice is sufficient then? And that was for how much, what period? The
Period for 5 years, ma'am.
5 years.
Mile. Time.
I want you for 1 year.
26 up to
So what is the present stage?
present stage, my lord.
He must not be interested.
Then the lordship directed for the fresh because the Sairat
We
could not.
don't know. We are just saying.
My lord, he is not
There
appearing.
was an order passed in 2021
My lord,
requiring him not to operate the sand sirer.
my lord.
So why should he be interested anymore?
Why have you not filed a counter?
We have filed counter.
Right?
Yes, yes.
22 mile
Okay.
since 2020.
So what is the position?
Position, my lord, the lease, my lord, the Sairat could not be settled, my lord, in view of interim order.
So what is your stand now?
My lord, if the interim order is modified, my lord, we will issue him the direction. Otherwise, we will go for the fresh auction, my lord. Because every day the local people are illegally lifting the sand.
Every day, and the interim order had not been extended on 16/9/2021.
As because the writ petition is pending, we could not able to answer. Proceed, my lord. Due to pendence of the writ petition.
No. The interim order was because it was till the next date.
My lord.
Next date, because he did not file requisites, only time was granted to file requisites. Interim order has not been extended.
My lord.
Then after 1 year, it was extended. Specifically.
Yes, so you withdraw this, allow them to come out with a first tender.
My
lord, my humble submission that the OP number 5 made that application in the pretext of that which he knew from in the date he participated in the auction. But after thereafter,
What benefit you are getting because of pendency of the present
because Milord, I was the second highest bidder, only difference is 60 rupees, Milord. I am also interested to, if I would have been issued the form F notice, immediately I could have deposited the amount. It is because of the OP number 5 and the OP number 4, Milord, who unnecessarily drag on the matter. I, the second highest bidder, could not deposit. The state would have been more enriched if I would have been allowed, Milord.
It seems that you and
My lord, my humble face
you and opposite party number 5 are friends.
My lord, face action would be better.
Exactly, that is what we are saying. Friends and illegal extraction during the meanwhile must be doing.
Without, yes.
My lord,
So both of you.
That is my humble summary of the record, my lord, that OP 5.
Of the record.
5.
Why not you?
My lord, because I was the second, I would have deposited the full amount. But my lord,
Now
the subterfuge is made by OP 5.
When was the notice issued? When was that tender notice issued? In 2021.
Yes.
January 2021. We are in 2024, end of June. So they can go for fresh tender.
Fresh tender. I am
So,
go for fresh tender.
yes, that
Yes, problem. Yes.
there is no representation on behalf of opposite party number 2.
5.
Opposite party number 5. learned counsel appearing on behalf of the petitioner does not have any objection if this writ application is disposed of with an observation that the opposite parties shall be at liberty to issue fresh tender notice for the sand query in question.
Question.
At
What name of the site?
Oglapur.
Uglapur.
Mahanadi
Mahanadi sandstone.
Mile.
Oglapur sand source. Oglapur Mahanadi sand source will be
Mile.
sand source. So, then counsel appearing on behalf of the opposite state opposite parties has submitted that because of the pendency of the present writ application, the authorities have not been able to come out with a fresh tender notice, which has led to illegal query of sand in the post of considering the facts and circumstances, this writ petition is disposed of with an observation that the who shall issue?
My lord, the mining officer now. Initially Tahsildar, now is the mining officer.
That the mining officer,
Kodamba, where?
Kotak.
mining officer, that the competent authority shall be at liberty to issue press tender notice for the sand query in question. So this application stands disposed of accordingly.
Obliged.
Item number 24.
Item number 24. My lords, this is a disposed of matter. I have filed one IA which is at flag K. IA was for extension of the time. My lords, what has happened? A direction was passed by this honorable court to pay rupees 6 lakhs as maintenance to the permanent alimony to the wife, which I have already paid. And there was an order to pay rupees 10 lakhs for the child by 31st of March 2024. Because I was unable to pay, I had filed this interim application. But my lords, to be fair, already 3 months have passed. So I am now in a position to pay. My only prayer is let them be directed to just serve a copy of the Aadhaar card and the birth certificate of the child, because I require that to make the term deposit. That is the only prayer I have right now. I'm not praying for extension anymore.
Where is the court's order?
My lords, the court's order is, your lordship may see order number 6. Order dated 7/2/2023, page 4.
Order number 6.
Order number 6. Paragraph 10, my lords.
Please for the other side.
For the other side. Yes, my lord, I am ready to hand over the copy of the Aadhaar card as required to deposit a term deposit.
Aadhaar card and birth certificate, both.
Yes, my lord. There's copy of the birth certificate.
This appeal was disposed of on 7/2/2023. based on settlement between the parties in following terms, paragraphs 9 and 10. An application IA number 131 of 2020, 131
131.
has been filed seeking extension of time for time filed by the appellant
Appellant.
for extension of time to comply with this court's order as noted above. Full stop. The appellant had sought for 3 months' time on the date of filing of this application, which period has already expired. And counsel for the appellant has submitted that the appellant has now arranged money to satisfy this court's order, to comply with this court's order dated, what is the date?
7/2/2023.
Stop. Learned counsel for the petitioner has submitted that for complying with the said order, in order to make term deposit, term deposit in favor of the appellant's daughter,
Yes, Manoj.
in the name of the appellant's daughter, the petitioner requires Aadhaar card and birth certificate, which are in possession of the respondent. And counsel for the respondent has submitted that the respondent shall furnish to learned counsel for the appellant the copy of the Aadhaar card, copies of the Aadhaar card and birth certificate of the respondent's daughter by tomorrow or 1 week.
1 week, within 1 week.
Their daughter by the
129.
within 1 week. Stop. He has also assured this court that the original copies of Aadhaar card and birth certificate shall be presented before the bank as and when required for the purpose of the term deposit in terms of this court's direction as noted above. So, in such view of the matter, this IA number so and so stands disposed of with an observation that let the respondent furnish a copy of the Aadhaar card and birth certificate. Copies of Aadhaar card and birth certificate to learn counsel for the petitioner within a week. Stop. The court expects that the appellant shall comply with the said order by this court's order. shall not fail to comply with the said order and take all possible steps to ensure that the term deposit as directed by the court's order is met.
My lord, I have a small prayer because the term deposit should be made in National Bank in Kotak.
You are staying in Cuttack?
Yes, I am staying in Kotak at Sankarpur.
My lords, the only difficulty is that the present appellant will not be able to travel. That is the only difficulty.
Why?
Because he suffers from this disorder known as ankylosing spondylitis disorder, which is a progressive disorder. That is the only problem.
Where does he stay?
He's in Balesur, my lords. Working in Balesur, work from home, he's in Balesur. That is the only problem. And had this ground been raised at the time of the final hearing of the appeal, I could have taken instructions.
We are listening to your thing, but won't it be inconvenient for the child? Child means must be grown up now. Child to, if it is done in Balesur, she will have to travel.
There's many problems. You get that.
My lords, shall I take instructions, my lords?
Over for phone you take?
Yes, my lords. I can.
You can inform us by.
Yes, my lords. At 2 p.m. I can inform. I can.
Just for that limited purpose.
Yes, my lords. 2 p.m.
He doesn't have to travel also. Somebody can come and do it also.
Lords, in a term deposit, probably one parent has to be.
Why is she a minor?
She's a minor. Yes, she's a minor.
Mother will be present.
Mother will be there.
Mother.
In fact, mother will be the guardian.
Mother is
Yes,
here.
yes.
Mother lives
She
in
has the
Cuttack.
custody also.
So all that you explain to him also.
yes,
Even if he says no, you can explain and
I will
use your
just-
prerogative to convince him.
Yes.
Item 25.
There is a delay of 517 days, my lord. The order passed by the Honorable Single Judge directing to regularize the service of the petitioner. The entire war charge period is to be regularized in terms of that Narsu Pradhan judgment. Lordship, similar matter, your lordship have issued notice.
Delhi copy not served, I copy not served. Unfiled objection. Copy served.
So he's accepting notice. So accepts notice on behalf of sole respondent.
Yes.
Sole respondent.
Oh, sorry. How much time?
2 weeks.
2 weeks time is allowed for him to file objection to the limitation petition. What is the delay? What is the explanation?
90 days.
Huh?
How many days delay?
517 days. 517 days.
What is your explanation?
The
And how many such cases are there?
number of cases, more than 100. What?
In all cases, there is delay of 517 days.
No, ma'am.
Whether any matter has been decided.
One matter, that is W number 432 of 2022. Lordship has fixed the date prior to vacation. It has not come. That is, at that point of time, the Advocate General is ready to argue the matter, but could not reach.
What is that matter?
That matter, that work charge employee was entitled to pension even if not regularized. The rule 18 of pension rule says, once a work charge employee is regularized, he is entitled to
So
pension.
therefore, we want to know whether there is any case pending where there is no delay.
That W 430, I am saying that W 432 of 2022.
That is ready for hearing.
Yes, ma'am. 432 of 2022.
Give your slip.
Yes.
That.
No date fixed.
List.
Last. So, 2 weeks. This after 2 weeks. Give this slip.
I have given this.
The hearing, one.
Item 26.
Yeah, my lord, sir, there is a delay of 250 days. The
Serious objection to this, Millers. This is a matter regarding the staff nurse. He was on study leave. And the leave period, no salary was granted. The Honorable Court considered the matter. Similar cases, others has been given the benefit, but discrimination was made, petition was not granted. And the decision not to pay is also contrary to their own resolution. In spite
Just
of
a
that,
this
only
which item?
because I have filed
This
a
just
con-
a-
26.
26.
26.
Which order is under challenge?
My lord, sir, worship, there is annexure 1.
Annexure 1.
Annexure 1 is it trying to come to the page 14 of the interim order. In view of such position, the order dated 4/9/2018 under annexure 6 passed by opposite party authority cannot be sustained in the eye of law, and the same is liable to be quashed and is hereby quashed. The matter is.
So you were in study leave for how long?
2 years study leave for pursuing MSc course. I'm a staff, BSc staff nurse. I obtained study leave and it was granted. And thereafter I completed my MSc course, that is a 2 years course. Thereafter I allowed to join. I am now continuing, but the period of study leave, now they are not paying salary for that period. That is why I have approached this honorable court. Now,
Where is the requirement for payment?
my lords,
Where is the requirement?
the study leave is to study leave granted means payment has to be made. In case of others also, they have granted study
Mr.
leave.
Counsel, there must be some rule.
180 of the Orissa Service Code.
Let us see.
Mr. Swai, you said that study leave was granted. I
Yes.
think study leave was granted.
Yes. With the permission. I applied for study leave was granted.
Oh, your prayer was to grant study leave with pay and DA.
Yes. That is, they say it is to be treated extraordinarily.
Extraordinarily is different.
Yes, now
You will
they are
have to-
treating it extraordinarily.
All right. Extraordinary leave means you don't have any leave admissible to you.
Yes.
Despite that, you are granted extraordinary leave. But for extraordinary leave, you will not get pay.
That they are now saying that. They are now saying that it is extraordinarily, we will not grant you any pay.
Right.
That is their stand.
Right. Where is the rule?
The rule is 180 of the service code.
Which rule?
180 of the service code. 179 study leave stats.
Service code.
Orissa
Service
code.
code. Odisha service code. Where the petitioner went on study leave and post facto sanction was sought from the government. But the service of the petitioner was regularized in 2017, my lord. Now, he rendered the service as contractual from 2009, and he continued as such. On completion of 6 years of service, his service was regularized in 2017, my lord, giving a retrospective effect from 8 to 2015. So, as per the rules, that is Odisha Service Code, not less than if a person not less than 5 years of service, he cannot be allowed to go for study leave. So, considering his date of regularization from service, he had not completed 5 years. So, post facto sanction was sought for by the director from the government in 2018 that the period he has undergone study leave by the permission of the authority means the superintendent. Not there was no sanction of the government. He went on study leave. Now that post facto approval, the government has treated that period as EOL, extraordinary leave.
Granted approval, but with that rider.
Yes, with that rider. So that
And
his
De-
service is
Devika
regularized,
Mishra-
but for that period, he will not get any financial benefit.
Probably she's a woman. Right? Devika?
He's a woman, yes, girl.
And similar benefit.
All right, we will take up the matter tomorrow.
Hands it over, I can.
I will hand over in 2 days.
All right. All right.
Yes, sir, I am over.
You'll hand over within
2 days.
2 days. All right.
2 weeks.
So you'll hand over within 2 days.
Morning.
Huh? What draft? Matter draft? ହଁ ସେଟା ତ କରାହବ ଟିକେ ଟିକେ ଦେଖି କରାହବ ସେଟା ଠିକ ଅଛି ସେ ଖାଲି କନଫର୍ମ କରିବାର ଥିଲା whether କଟକରେ ହବ କି ନାହିଁ ସେଟା ଯୋଡା ହେଇଯିବ ଗୋଟେ ମାନ ନା
You want to make any mention?
Lordship, the urgent matter, Lordship, regarding Jagannath, Lordship, this in relates to the car festival. In fact, Lordship, here tradition is, Lordship, before this car festival, Lordship, people used to, Lordship, visit Alarnath, that is 20 kilometers away from Brahmagiri, from Puri district. But remaining this period, Lordship, when Jagannath is in temple, Lordship. In fact, there is a judicial order, and which has been commenced from Lordship from since 23rd June 2024, and it will continue till 5th July 2024. There is judicial order, Lordship, how the devotees will go and visit the temple and to make darshan of Alarnath, Lordship. By misinterpreting, Lordship, below they are not allowing to see the Lordship to touch the sacred Lordship, pit Lordship, which is Lordship is a culture, Jagannath culture.
Where is that matter listed?
Matter, Lordship, in fact, Lordship, we file a petition.
So you should have mentioned in the morning. This is not the time.
Lordship, that's true, Lordship.
Mention tomorrow.
Lordship, grateful, Lordship.
Please, Your Lordship. Plus, in item 1, we have filed one affidavit today. Of course, e-file also. The hard copy were filed.
His nickname is Helmet.
Para 5, yes, Para 5 relates to the boy who has been rescued and produced before Lordship in chamber. Para 5. Because out of the 5 missing children, 4 have been rescued in the meantime.
And who is the other ones?
Other one, that is, you also get it, paragraph 10, that is one Muhammad Imtiaz, who was missing from Puri, Utkal Balasam.
He could not be, he is missing since?
Yes, plus investigation on, and we are trying to get him, but by now we have not got that child.
He is missing since when? Since when he is missing?
Since plus 5th June 2000. 1 minute, please. I'm just looking. I was missing last affidavit. Also get it from order dated 21/5/2024.
The Regent suo motu petition was instituted based on a report submitted by the Secretary Juvenile Justice Committee, High Court of Orissa, which disclosed inter alia a fact that one of the children was missing from Utkal Balashram, Khapudia, Cuttack.
23rd August.
Stop. Under certain orders passed by this court, efforts were made to rescue the child and produce him before this court. Stop. The child was rescued and produced before this court, before a coordinate bench of this court on 18/5/2024.
That was 28th May.
28/5/2024.
Yeah, 28th May.
Stop. The said child was brought to the court today, with whom we interacted in chambers. Stop. Next, during the course of hearing of the suo motu petition, based on the writ petition, it emerged that 5 children were missing from various Utkal Balashram in the state of Odisha. Stop. Today, an affidavit has been filed on behalf of
by the DGP Mlas.
By the Director General of Odisha, on behalf of the Director General of Police Odisha, stating therein that
Do you acknowledge paragraph 4 Mlas, that relates to all the missing children and details where they have been missed and on what dates? Paragraph 4.
4 out of 5, including the present child, have been rescued. Stop. It is still missing.
The person you mentioned from Puri,
Yes,
missing since 2018.
2008. 23rd August 2018. And paragraph 10 we have written in details.
That he belongs to outside the state.
Yes,
his
of the
address
state,
could
even we are
be
not getting the
verified.
details, exact details. And the details, whatever available in the child care institute, is found to be incorrect. That's the whole issue for which we are not getting it.
Paragraph 10.
It has, however, been stated that one imtiaz, that
Pardon, Muhammad Imtiaz.
one of the children who is missing since 23/8/2018 is still missing
Balasram Puri.
from Utkal Balasram, Puri. Full stop.
He had provided the names and addresses of contact
Yes, that's the
persons,
reason.
but all found to be fake.
Next. We do appreciate the sincere efforts made by the police administration and the officials of the welfare department,
What is the department?
women and child development department, government of Odisha, for making sincere efforts to ensure that the children missing from various Utkal Balasrams are rescued. Stop. At the same time, we express our concern for the reason that only after intervention of this court in the present proceeding, the actions were taken. So stop. We for the present, we direct the opposite parties to take all possible steps to ensure the whereabouts of the child missing from Utkal Balasram, Puri. Stop. What about learned additional government advocate has produced before us a report on the plan for rehabilitation, economic stability, and future well-being of the child who has been produced before us, which reads as under main neighborhoods. Stop. What about other children?
One children is missing now.
No, about one you have prepared a plan.
Your lordship will get.
What about other
They have been
three?
restored to the parents.
Yes, my lord.
All major.
Yes, all measures. Paragraph 7 that relates to Padmini Khadia was missing from Utkal Balasam Sambalpur. And in paragraph 8, we have written about Subhajit Dinda.
No, we are saying something else. We are saying that you have some plan for rehabilitation of this boy who has been produced before us.
Suman Saw is already married. And Suman Saw is already married. Padmini Khadia is also married.
Married.
Yes.
Married
Yes,
and
still.
Subhajit Dinda has run away thrice, 4 times, different places
With
in
much
India.
difficulty, we have rescued him from 210 kilometers from Maharashtra, Bombay. And his name was also not clear. His address was not clear.
So someone is there from welfare department or welfare department.
Are all from Balasram only. The gentleman is from the department.
WCD. Program officer.
So what do you propose to do for other children? Don't have any idea.
For every children, we have individual care plan. So children who are staying in child care institutions. And accordingly, their health, education and other rehabilitation part we are looking after. And each child care institution having professional there who are planning for their whole rehabilitation plan. And we are also, the child welfare committee also reviewing these plans once in 6 months.
And whether the condition of this Balasram has improved or not?
Yes, sir. Actually, we have also, as per your honorable order, we have also collected the status of each Utkal functioning in the state.
How many? 40?
17.
17.
File an affidavit.
Yes, ma'am.
Stop. Let an additional affidavit be filed on behalf of the social welfare. What is that?
Child and welfare.
Child and
Women,
welfare
women and child welfare.
Women and Child Welfare Department, Bhubaneswar, stating as to what steps are being taken for improving the condition of various balasrams in the state of Odisha. Various Utkal balas.
One affidavit is filed on 7th May. We'll file another affidavit. Obliged.
We can send someone to visit to Utkal balasrams.
Yes.
And you will have to say as to which is in the worst condition and which is the best. So we shall ask someone to visit and then decide what. So you can tell us which is in the worst condition.
That's it.
Discuss with the director.
After discussion, we'll also let you
So this is not, we will not blame you. We will rather help you. All right. It's improving the condition. So therefore, you can frankly say that the condition of this Utkal balasram is not up to mark or very bad.
Yes.
There will be so many circumstances. So we shall see what can be done.
Certainly, we'll convey your lordship after having discussion with the director.
Let this case on.
The director has the affidavit filed by the director, Women and Child Development, Ms. Banerjee. She's given an exhaustive SOP that is being followed in all Utkal balasrams.
That may affidavit.
Yes, may affidavit. It's very exhaustive, but nevertheless, my lord, we'll file an additional one and see what can be done.
Please. 3 weeks. In the meanwhile, you do something. If something is required to be done.
Yes.
Skill development is one of the most important aspects.
Because this boy has run away and is a helper in a bus earning money. And only teaching them, nothing will happen. They'll drop out of school.
No, there are vocational training part also.
Honorable we have planned for vocational training, skill training.
That is there.
That is there.
They are being taught.
Yes.
As per the age.
Actually, last year, 2023-24, we have 154 children who have got skill training and also got job placement also.
Very good.
We'll put it in details in the affidavit.
About the skill training mainly you.
Yes.
Item 26.
Item 26 has gone through the records. There is a application for condonation of delay filed by the state government. There is more than 250 days delay and no explanation has been given to this. Only after filing my contempt application, they have filed the condonation of delay application and this application, this appeal.
So we'll just see the order.
Yes, please. That is in the order. There is IA number 5608. No explanation has been given with regard to delay. Why there has been such a long delay?
Yes, we will see later, but
250 days delay.
see, this is a question of law which requires to be decided.
With regard to this, Millards, similar cases, more than 5 to 6%, they have already granted leave. Those are prosecuted MSc nursing. And the leave has been sanctioned with pay. But there has been discrimination in my case. I have given an affidavit, all this is Annex 12 is the government resolution, and Annex 13 is a similar person to whom they have granted this. Annex 12 to my rejoinder in the writ application. We'll also turn to page 9.
How do you justify this, that similarly situated persons?
I've
who
given
had-
an affidavit, there all orders, everything I've annexed.
Like?
I've annexed everything. That is to my rejoinder affidavit filed in the WPC number 1059 by 2019. We kindly turn to.
In the counter affidavit,
Yes,
Lord,
just a
we
minute.
have specifically stated.
Specifically
that
stated all these things. No reply
set
has
of
been given to
persons-
that. And in the order of the Lord Single Judge, they have also specifically referred to this, and the no reply, because the no reply, they have relied on this document. Annexure 7, you also kindly turn to Annexure 7 to my rejoinder affidavit. Page 7, Annexure 12. That the objection they have raised, 5 years experience I don't have. With regard to that.
Annexure 7.
Is page 7, Annexure 12 to my rejoinder affidavit to the writ application. The writ application.
Annexures
Annexure 12.
12, there, Mr. Das, that notification says that 5 actual period will be considered
Yes.
for the purpose of study leave.
So come to Annexure 12.
That is the only ground they have taken.
This was in 2020, of course.
Yes, ma'am. That is.
When did you do?
It is 2020, but
When was your study leave?
17.
That is the problem.
My leave was
prior to
from.
that.
Prior to that. But rule are you. Next page.
And
And
their
page
services were
9.
treated as EOL in 2018, much prior to commencement of this.
No. This is a clarification given to the rule. It is not that first time it has come. And the Annexure 9 page,
Clarification has been
next
given in
page.
2020.
Next page, page 9, I have given the gradation list and there are also letters. You have serial number 21, 22, 27.
Just a
And
minute, just a minute. Come to page Annexure 12 of the writ petition.
Part of the rejoinder.
Yes. Yes, my lord. The notification 25/8/2020. In continuation to the department notification 21/2020, after careful consideration, the government has been pleased to allow the past service of the staff nurse, those who have already been regularized on completion of 6 years of contractual service. The contractual service period will be treated as government service for the purpose of computation of 5 years of regular service under section 180 of the OSC rule for grant of study leave in their favor. This has been concurred by the GA and PG department 2020.
So why this discrimination?
My lord, so far as the petitioner is concerned, my lord, the study leave was initially not granted. In fact, she was relieved on study leave by the superintendent in 2015. Now, after 2 years of completion of that study leave period, claimed to be study leave period, she was allowed to join by the superintendent. Thereafter, she moved an application that my case be sanctioned by the government for that period. Now, in 2017, his service was regularized considering a government resolution that on completion of 6 years of service, your service will be regularized. So regularized was given effect 1 year, 5 months prior to the date he was relieved on study leave. So if your lordship will look at the statutory provisions, then a person who has not worked for at least 5 years shall not go on study leave. So since post facto
But
regularization,
for that purpose, the contractual period was also to be taken into account.
Has not worked or has not worked in that post.
but my lord, the post facto sanction was moved by the director. Then the sanction was granted by the annexure 1 to the counter affidavit, your lordship may kindly see. That sanction was granted in 4/9/2018, which is much prior to the commencement of this circular.
Which circular?
This this government resolution of 2020.
That must have been passed considering the hardship faced by these staff
And
nurses.
not only in case of the petitioner, but also all similarly placed. Your lordship may kindly have a glance to page 20, annexure 1 series to the counter affidavit. Just annexure 1 series. Srimati Devika Mishra, period of leave 17/11/2015 to 16/11/2017, treated as EAOI. And the same order at page 21 passed in case of one Sangeeta Kumari Mishra, one Sasmita Sethi, page 22, 23 Sasmita Pradhan, in almost all cases. Now this 2020 resolution came later. This resolution came later, and this resolution has no application so far as the case of the present petitioner is concerned. That is my submission.
Do you mean to say that anybody who has availed study leave in these circumstances before 2020 has not been granted? Not a single case?
That is our case.
No, that may be a case, but
Then I'll have
sure.
to file an affidavit to that effect to find out, because that is not on record.
That is on record, my lord, that is at page 9.
Mr. Swami, have you checked that?
Yes,
they had
I've given the
availed earlier?
documents.
No. They had availed earlier before this resolution came into force.
No, prior to that resolution also, they have granted leave to the person.
That is what we are asking.
Yes.
So which page is that?
The stand that now they are taking is
Which
not
page is that? What
page
is it?
9 to my agenda. That is the graduation list.
Which number? 189.
You also kindly turn to page 5. I have prepared a chart relying upon the graduation list.
So that's paragraph 11 of the rejoinder. You see? Specific details they have given, taken probably from the gradation list.
But that gradation list, which my learned senior is referring to, that doesn't disclose regarding whether that study leave period has been treated as EOL. Your Lordship,
Go to page 58.
page 58. My lord, refer to page 58.
That's fine.
No, that is
I have a doubt.
page 11.
I have a doubt.
Page 11 to my rejoinder.
Annexus 15.
Annexure 14.
Annexure 15.
Annexure 15 is the resolution. Yes,
They have,
they are
they have
studied.
said every year 4 persons will be sponsored.
No.
So if beyond 4, that means you have gone out of your own without being selected
No, I am been selected. I was first in the selection merit list.
for going for study.
Yes, yes. Only after that was allowed.
Selected by whom?
By the government.
As
There was a selection process. I was selected. I stood first. And after that, study was granted. They say, because you are continuing on contractual basis, we will not allow you. They didn't allow me. Therefore, I have approached this Honorable Court. The Honorable Court considered the matter and directed them to consider. They considered and allowed me to go on study leave. Now, they are saying that because 5 years you have not completed as a regular employee, so we will not allow you.
No. They allowed you to go on study leave pursuant to order of this court. But
Yes.
is it as per this resolution that every year 4 will be allowed?
Even 4% that.
If 4 are allowed, for 4 they must be giving that leave.
Even if 4, then also my case will be considered. Even if 4, then also my case will be because I am first.
No, but please come to rule 192.
And there also kindly only one page, page 11, also kindly turn to page 11. That will suffice.
See whether Odisha's service code is statutory in character or not.
It's a code.
It's not statute.
Government used to pass.
No force of law, according to you.
It's a law, they are following it.
No, you can say if
Yes,
it
they're
has
following.
force of law, it's all right. If it's, the
following.
code is just a kind of executive instruction.
Yes.
There also you may be correct. But what is this? So code?
Yes.
Rule? Now come to rule 192.
Yes. Half hours people drawn during study leave. No, my case is applicable to, they are referring to 179. That is
They may be referring to, but we have to read the rules.
Yes, no. Well, application for study leave should be submitted. During study leave, a government servant will draw half hours pay as defined in rule Rule 10, subject to the maximum and minimum laid down in Rule 166 and 167. The rate of exchange applicable to the conversion of leave salary other than that admissible during first 4 months of a period of leave on average pay shall apply to study leave allowances. The government servant may, subject to the approval of the proper authorities, being obtained, undertake, or commerce or commence a course of study during leave on average pay and subject to Rule 187 and 188, draw study allowance in respect thereof, provided that study allowances is not drawn on for an aggregate period exceeding 2 years. It is 18 months in case of officers falling under Rule 181A. During
This is
whole
what happens when, without addressing the rules, the matters are decided.
And
So there is utter confusion. Some decision taken by some authority, therefore Article 14, same should be applied in your case also. Whether that decision was legal or illegal, irrespective of that fact. Because some rule was violated in one case, the government must violate that rule in all other cases. This is the logic that is given for grant of.
Not on that. No. My case is considered under section 179. Also, can I turn to 179? My case is under 179. That the grant of special study leave, subject to the conditions hereinafter specified, the state government may grant special study leave to a government servant to enable him to study scientific, technical, or similar problems, or to undergo a special course of instruction. Such leave is not debited against the leave account.
Yes, this is subject to conditions.
Yes. So all others' case has been considered under this rule. But in my case, they say because you don't have 5 years experience, we will not allow. You also kindly turn to their own letter leave granted. You kindly turn to page 11.
Lordship, may I kindly have a glance to Rule 1?
Please, one by one.
I'm sorry.
Page 9 is the gradation list in which their date of entry into government service and their seniority. In that case, serial number 21, 22, 27 and 31, they have gone on study leave for MSc nursing course. They have allowed. And the letter is 7/2/2013, Annexure 14, under which they are allowed to go. That is Shri Lakshmi Behera, Samapika Dehuri, Lakshminarayan Sen, Nayana Kumari Samal. These are the 4 persons who are allowed. Serial number 1, 3, 4, all these things. And their order under which leave was granted, I'm reading it out to us. Annexure 14A, page 12.
And you are a member of subordinate service or what?
I'm a staff nurse.
It's a subordinate service or what?
Yes, staff nurse.
So come to note under Rule 179.
Note. Save in very exceptional cases, study will not be granted to a member of subordinate service. I'll check up that myself.
Therefore, it involves question of law.
No, this part I will check up because
prayer for condonation of delay shall be considered at the time of admission. What is this matter for admission on?
Is there any difference between study leave and special study leave? Because the terms have been used differently in different clauses you check up.
See, just think of a circumstance where a class 3 employee wants to go for PhD in astrophysics. All right. And that leave is granted. So that will be this thing. He will be on.
Must be some relevance with the
What is the relevance?
post he is holding. No, he is MSc nursing.
No,
studying.
maybe serving
He's
in the
a
Department of
staff
Science.
nurse. He's a
Class three employee may be serving in the Department of Science and Technology. He is having the qualification of MSc. Now he gets an opportunity to do PhD in astrophysics.
I
The
got
fact
the point.
remains that he is a member, he is a class 3 employee working as a clerk, but because he is MSc and he is working in Science and Technology department, therefore he can add to that department, to the efficiency of the Department of Science and Technology.
That I understand, Milord, because
And
there is
therefore
no
that note is there.
Here in the present case, he's a staff nurse. He's a BSc nurse, nursing.
Yes.
And he want to pursue MSc nursing.
Right, we understand.
So, yes.
We understand.
So in this
there
case,
are two things.
it is relevant.
See, you have, if your contention is accepted, then it is not a case of grant of study leave. It's a case of the state sponsoring your case for higher studies with full pay and allowances. That is different. And therefore, when we decide such matters, we are required to examine the rules.
All relevant documents.
And that notification which you are pointing out is with reference to under 180 of the.
Please,
Service.
Please come prepared. Please examine all the statutory provisions. There must be decisions also of the courts on this point, and then address. Because it's a peculiar situation. And the worst thing is that in most of the cases, a plea is taken that in this case, this decision was taken. Therefore, that decision should be taken in this case also. We need to examine whether that decision was legal or illegal. We do not follow illegality.
Got the point.
Because some illegality was done, therefore the court should follow that illegality. That is not the law.
Correct. You'll also fix up
4 weeks. Please examine. It involves an important question.
Mr. Das, you also check that resolution has reference to 180.
180, I was referring to 180 because that
Half leave.
half leave, and that particularly speaks that unless a person completes 5 years of service, he is not allowed to go for a study.
No, just tell us, how did he or she go on leave? How?
That is basing on a resolution of the government.
Well, it was granted by someone. Some of us. Validly or not. Whether that grant of leave was valid or not.
In fact, that grant of leave
was valid.
Was not valid. I would rather say it is not valid because they sought for the post facto approval of the government subsequently.
So whether he had the competence to grant leave or not.
So why you give us a date chart also?
I'll address on that point.
And if he did not have the competence and with his permission he proceeded on leave, then you will have to tell us what action did you take against him or what corrective measures have been taken. And it appears that it's a complete situation of misrule. Your governance is being conducted by circulars and resolutions. We'll see.
Item 38.
Mr. Sampath is online.
Yes.
Lordship, see the last order. Order number 86.
Yes.
Lordship was pleased to reject all the intervention applications.
That we have done.
And Mr. Sampath is online. The Lordship can please.
Yes.
Good afternoon, my lord.
Yes, Mr.
Yeah, actually, as a prelude to whatever action we have to take for stakeholder consultation, we have prepared a detailed questionnaire and then circulated to all the people concerned in the field. And we wanted to have the stakeholder consultation starting from the first week of July. And once the consultation starts and then, we collect the information, it may take a month or so for us to compile all the data collected from them and then prepare the draft policy maybe by the middle of August and things like that. And then we may be in a position to complete the exercise by end of August. And then thereafter, we can again go back to the stakeholders and then get their views on the policy, draft policy. And then finally, the state government will have to take action for notifying it, by following the prescribed procedures. I think this is my timeline, which I have worked out in consultation with the fisheries department. And then we will go according to this and then see that, by the end of August at least, a draft is submitted to the state government.
End of
August.
End of August. So whatever you have submitted right now, can you give us this small write-up so that we can incorporate that in our order?
Right.
So we can take up can we take up the matter tomorrow? Please join online again.
Yeah.
And please send your this thing, short write-up.
Yes.
We
Maybe
can,
about a
so that we
two-page.
can incorporate that in our order.
Yeah.
And then whatever you submit, that shall be the guiding direction for this court to proceed further in the matter.
Right.
Should we do that?
Yeah, sure.
Yes, Dr. Ritesh.
Sir, this is completely aligned, sir. We have been discussing together.
Right. So that we can do.
Yes,
We
sir.
can. We would suggest that just you will be giving this court a direction for this court to issue further orders in this matter. So just give us things brief write-up. We shall incorporate that.
Right.
Point wise, then we shall proceed.
Right.
So we are listing this matter tomorrow. How will you send that, Mr.?
I will send it through the state government, fisheries department. I have the contacts with them. And even Mr. Anrup is there, we can
Yes,
share it with him.
our counsel is there in revenue department. He will collect it and send it to me.
Tomorrow.
Yeah.
Tomorrow. No, he can do. They have already done it. They're just.
That's the copy of the what has been submitted by the expert that will kindly supply to the stakeholder.
No, that will not be supplied to you. Whatever, just a minute, whatever is sent by him shall be incorporated in our order. And that can be seen by anyone in the world. All right. So you are not required to have a copy.
We are the stakeholders. We are the affected parties in the case, Lordship.
But their
Can we know
intervention has been
the
taken.
communication process so that we can have our communication to the experts those are appearing in the matter.
Mr. Counsel, you want their reports. That report will be there in the order. That order shall be uploaded. You can do whatever you want to do, but please don't interfere in the present proceeding. It's a PIL. You had filed intervention application.
That has been rejected.
Now next time you stand up for any submission, we will impose cost on you. We are on a different point altogether. If you have to challenge something, you challenge before appropriate forum, not stand up. Be careful in future. Mr. V. Sampath and Dr. Ritesh Kumar have joined online. Full stop. Certain exercise has been carried out after the last order dated 25/2024 was passed. First off, we request Mr. V. Sampath and Dr. Ritesh Kumar to prepare a short write-up before a write-up through learned. Who is the counsel?
I am the counsel, but there is one consultant, Mr. Anurup Mohanty Advocate, who is the consultant of Revenue
Through
Department.
Mr.
He will give it to
Anurup.
him. Anurup Mohanty Advocate.
Anurup Mohanty for this court to consider and pass appropriate orders in this matter. Yes, will that do, Mr. Sam?
Yeah, sure.
Consultant in the revenue department.
Yes, ma'am. Consultant in the revenue and disaster. Advocate. Legal counsel.
Consultant in the revenue department.
He is an advocate.
Consultant in the revenue department, bracket, and advocate of this court.
Yes.
Please ensure that.
Yes, yes. Tomorrow we'll give the status report.
Tomorrow.
Your Lordship may take it at 2 p.m.
2 p.m.
Yes.
Item number 27.
Some limitation on 1/5/2024, but none has appeared.
How much delay?
There is, they filed on 2/11/2022. Order is 2/11 to around 300 days. That's similar to item 4, that is pension of block grant employees. The Lordship dispute of the similar matter at serial number 4. That is dispute upon the very first day. That is similar to item 4, your Lordship has passed 2 days.
So what order did we pass in item 4?
That your Lordship remanded the matter to the Honorable Single Judge for giving the opportunity for hearing.
Service of notice. Good morning, little.
Page. Notice is delivered.
Yes, yes.
IA number?
That IA number 8556. But in the meantime, that certified copy has been filed, and another 8555 is for condonation of delay. 2 IAs are there. One for dispensing with. In the meantime, certified copy has been filed. So that has become infructuous.
8555. The application has become infructuous.
8556
556
has become infructuous.
8555. 8555. This application has been filed seeking condonation or delay of 300 days in 366 days delay in preferring the appeal. Stop. Despite service of notice, there is no representation on behalf of the appellant. Stop. The order impugned in the present case is dated to
No, 19 days. But no, it's not enough time, I thought, but. The appearance in the notice was fixed to 19/6. At least this one. Sometimes they miss the appearance and doesn't come on record.
So we can adjourn it now. We are adjourning it.
Yes, ma'am.
There is no representation on.
Date of appearance was fixed to 19/6.
Well,
One date.
Another date, ma'am.
Place this case on. So and so. We make it clear that if there is no representation on behalf of the respondent on the said date, the court will consider passing appropriate orders on the limitation petition. Whether any Vakaltama has been filed? No.
Well, right now they must have. In the meanwhile,
Will the registry verify as to whether any Vakalatnama verify if any Vakalatnama is filed in the meanwhile on behalf of the respondent. Our rules.
No.
1 week.
Item 28.
My lord, the matter relating to non-return of the original matriculation and a +2 signed certificate. My lord, due to non-payment of the hostel charges during lockdown period, my lord. My lord, petitioner is the student of computer science and engineering at Dreams Autonomous College. And during the lockdown period.
So where were you studying?
My lord, opposite party number 2, my lord.
Who is opposite party number 2?
Dreams, Principal Dreams Tangi.
Dream?
Dream, Dhaneshwara Ratha Engineering Institute of Management and.
It's a private or government?
Private, my lord.
Then
Private organization.
how can you maintain the writ petition? How can you maintain? For this purpose?
My lord, my certificate.
Certificate you could have approached the appropriate forum.
My lord, that observation.
And counsel for the petitioner after some argument seeks permission to withdraw this writ petition, which has been filed against private opposite party, bracketed OP number 2, which has been filed seeking direction against opposite party number 2, which is not stayed within the meaning of Article 12 of the Constitution of India. Top. It seeks liberty to pursue his remedy before appropriate forum. Topic. This application is allowed to be withdrawn and stands disposed of with the liberty as sought.
Item 29.
Also, your lordship, here the petitioner wants. I'm sorry.
Yes.
the IL matter.
application has become infructuous. It stands disposed of accordingly.
31.
May I please, your lordship. Opposite party number 728, my lord.
कौन
Here is
पंडा? तीर्थंकर पंडा,
Trinath.
त्रिनाथ पंडा,
Tirnath Panda.
वो दे file before appropriate. Encroachment on a public land.
government goods land. They have enclosed the private.
30 टी फाइल दे ले चलेगा
त्रिनाथ पंडा.
Obliged.
second copy of brief not filed.
Second copy.
No, one. Yes. Not even online. One he said that he wants to withdraw it. Fine. Order not to stand. In order. Order is 8 Order is not there. Okay, 8/5/2024 that nothing. See, there also copy paste there. 23/4.
August 2023.
Yes.
Item 32.
In 32, my lord, notice was issued on 7/5/2024 on the question of limitation, but none has appeared. It appears. There is a limitation of 495 days. This is regarding that work charge matter, similar matter that 432 of 2022. If your lordship will decide that matter, all the matters will be governed by that case.
No, first of all, whether we control the delay or not.
Yes, the principle is to be decided in 432. The principle in that case, there is no limitation. That the leading matter is that 432.
Get that decided first.
Hello?
Similar to item 25.
Yes.
What have we done in 25?
Yes, 25 टा कौन है ना? Notice?
Notice 2 weeks.
2 weeks.
Despite notice, there is no representation on behalf of the respondent. Let's discuss per week.
Item 33.
33 also same to 32. For the matter.
Certified copies you filed? No.
Hello?
Certified copies have they been filed? No.
I'm verifying.
Those Miss IAs are there.
I am personally monitoring the.
Yes, my lord. It will be filed within 7 days. I'll file.
I am personally monitoring
Yes, my lord.
the question of issuance of certified
Yes.
copies.
My lord.
So I have been told that henceforth, within 2-3 days, the certified copies shall be issued, even in the absence of any order passed by the court.
My lord.
So if you make your application online, you are not required to pay any fee and you get the order immediately thereafter, soon thereafter.
Right.
If otherwise you file a physical application, even then. So.
No, these are old applications from the mail.
Item 34.
34, my lord, your lordship has already issued notice. No one has appeared. There is a, my lord, your lordship may see there is a noting. Fresh notice could not be issued due to filing of incomplete requisites. Request for response and have not been filed. I'll take steps for filing of that within 2 days.
1 week time is allowed for the applicants to take the steps to file fresh requisites for respond number 7 and 8.
Well,
Item 35.
For issuance of notice to response number 7.
But here there is a delay of 256 days. But the issue involved, and here the Honorable Single Judge disposed of the writ application petitioner to be considered in terms of the judgment passed by Malayananda Sethi. But the fact of Malayananda Sethi doesn't apply to the present case, because here the death occurred in 97 and the petitioner made application for appointment under the rehabilitation scheme in 2015. That is almost after 18 years, my lord. Then his application was
Then limitation, on the point of limitation, we can issue notice. Issue notice, this point of.
36.
36 मतलब the 297 days delay. But I pray, my lord, you'll also call this matter next week. Why I'm praying, basing on order passed in another case, this case has been disposed of. So I have to verify whether that order has been challenged or not. Let's call this matter next week so that I can.
As requested on behalf of the petitioner, list this matter on 1 week.
For admission, item 37.
In item 37, your lordship has directed me to submit a notification. The old notification, I have obtained an instruction that it will take some time. Collector has given a letter to me that 2 weeks time maybe.
Oh, what is this matter about?
That sub-collector, your lordship knows.
Oh, yes.
That notification. Just.
Tahsildar or sub-collector?
Yes. Whether Tahsildar is the OA collector or not. That notification, 2 weeks time, because it is old records they are getting.
Well, can I just pray one thing, my lord? Let him take time. My friend actually is getting married first week of July. So after 22nd, any day, you also fix.
Yes, he's getting married.
As jointly, yes, you don't have to.
Because I have got a invitation card from him.
News evidence.
Yes. I just corroborate because today itself he has given me the invitation card.
Before this case was taken up.
No, in the first hour. He and his wife also gave because both of them are lawyers.
Therefore, you are not objecting.
Getting married, he and his wife.
He's getting married to a girl who is also a advocate.
Fiancé, don't say wife. He and his wife.
Fiancé. Okay. Sorry. Fiancé.
As jointly requested, list this matter on 22nd.
After 22nd.
22nd July.
23rd, 24th. I think.
July, 24th.
So, July, week commencing 29th, if you're
29th.
Yes, 29th is
July.
good.
Grateful. Interim order. But interim order is there.
Interim order shall continue in the meanwhile.
Grateful.
Item note 39.
In item number 39, there is a writ appeal regarding the appointment of Anganwadi worker. In this appeal, I have challenged the order of the single judge. That was my petition was dismissed on ground of residence. And another thing is that the single judge has observed that my case was not taken up during the selection.
So you're actually interested in the case. Twice it was listed, nobody came, we adjourned it on our own. It was listed yesterday, it was listed last week.
It was not listed.
Yes.
Yes, sir.
Anyway, You're here, it's all.
Then apology for the. So my case is that my candidature has been taken up by the appointment authority. When I
That
found,
matter has been decided.
my lord,
You are not, that is the case, that you are not a resident of the Anganwadi area.
no, my lord. I am the very much resident of that Anganwadi area. After
is your
appointment, after I have selected, they took a plea in the appeal stage that I am not a resident of that area.
So that objection they could not have taken after your selection.
After my selection on the same day, they have issued the letter and they have another issued another letter in same number and same date, my lord.
The question is whether you had the qualification or not.
Yes.
One of the qualifications was that you should be a resident of the Anganwadi area.
My lord.
The conclusion is that you are not a resident of Anganwadi.
No, that is not a conclusion, my lord. Because when I have already selected, they took inquiry whether I am in that Anganwadi center or not.
If there is an allegation, is there any wrong in making an inquiry?
No. Within one time after appointing the second candidate, they took the inquiry. That is a fault, my lord. My lord, see the page number 15. 15 to 17, my name is there in the selection list.
Sir, the council, that is not the question. The question is that you are not a resident of that area.
There is no document to prove that I am not a resident of that area. They have not, my lord, see their counter.
What document will be required?
How they fix the Anganwadi area center. They have not, in advertisement also, they have not indicated that which area it is there. And in 2023, they make an inquiry after the single judge bench order that I am not a resident of that area. In their
area, that's all.
You mean to say you change your residence after the order, after you were selected?
Because my lord, in one village, there are 2 Anganwadi centers. I am the resident of that Anganwadi center. But in there are many household in the village. They create such a way that excluding my house and said that he is not included in that list.
So that is there. How can we decide?
My lord, how they manipulate, there is the document, my lord. How they manipulate the document.
No.
See the.
We will not enter into those.
My lord, page 15 to 17, my name is there.
No, we will not enter into those things.
They are already manipulated, my lord. And also in counter, in
Who has
regent.
manipulated?
My lord?
Who has manipulated?
The appointing authority, my lord.
How?
I want to convince my lord. In regender, my lord may see page number.
Mister, who has manipulated or manufactured? Someone has manufactured documents.
Yes, my lord.
Then you could have filed a criminal case.
No, in this matter also I want to draw your lordship attention. How they exclude my name in the same day with same letter number and in same notice. In single day, my lord.
Yes, we do not find any illegal.
My lord, kind of mention the page number 17. Just I want to kind of attention. Then another point is, my lord, if that point is not counter affidavit of the state, my lord. page number 8. What is written? Application for selection of volunteer to work as Anganwadi worker will be invited for each village or Anganwadi center area. If I am not in the Anganwadi center area, if my lord convinced, I am the resident of that village. That is not disputed. It is written village or Anganwadi center area. I am from the village. If the second point is also satisfied.
Why is it stated village and Anganwadi area? Because if one Anganwadi center in the village, then village will be taken.
But that
If
is
there are
not
more than
clarified,
two,
my
it
lord.
has to be the area.
Yes, but that is not clarified. Only it is written that village or Anganwadi center.
The object behind writing that is so that if you are in the area, you will do better service. You can come.
Only one village, my lord, and two sides. One Lodha side and one Patna side. In one village.
The two centers.
Yes, my lord. And in one
center
village.
for each side.
Yes, my lord. And it is not proved that I am not in that Anganwadi center area also.
Proved in what way?
After appointment, I have been appointed. Then in the same day, they rejected. When I appealed before the sub-collector, they took that plea. My lord. That is the second thing, my lord. If I am unable to satisfy my.
In 2016, you filed the resolution.
My lord.
Your written petition was dismissed for default in 2018. Then you filed an application for restoration. In 2019, that restoration application was allowed. And thereafter, 3 years after you filed the written petition, your matter was right. 3 years because of this. Not because of any. And then.
My lord, petitioner is a woman and so there is some
The
coordination.
other side
is also a woman. No issue, but my lord, as the matter is before my lordship, and for the interest of justice, my lordship will decide the. No, my lord, no, that is that. But in my lord, in single bench judge order, another thing is that another point I want to highlight, my lord. My lord, single judge observed that my candidature was not taken up, but already I have been selected on the same day.
That we will clarify. The appellate has put to challenge an order dated 21/2020, passed by a learned single judge of this court in WPC number 2935 of 2016. So, the dispute relates to engagement as Anganwadi worker of Patna Sahi Anganwadi Center under Tangi block in the district of Khurda. So stop. The said Anganwadi center is in which village?
Gopal Prasad.
Huh?
Gopal Prasad.
Gopal
Prasad.
village.
Gopal Prasad.
In the village Gopal Prasad. So stop. It is not in dispute. Now it is an admitted fact that there are 2 Anganwadi centers for catering the need of 2 distinguished areas under the said village. So stop. The appellant had applied for her engagement as Anganwadi worker in Patna Sahi Anganwadi Center. So stop. It is her case that she was that based on her qualification, based on her academic qualification, she stood first among the applicants. First off, accordingly, an order of engagement was issued, whereafter she joined. First off, the opposite party number 5 challenged.
My lord.
The respondent number 5 challenged the selection of.
Not my lord, not the.
Opposite party number 5 was appointed.
Appointed, not challenged.
I challenge.
Later, it was found that the appellant was not residing within the area of Patna Sahi Anganwadi Center. First off, after having conducted an inquiry, who is the authority?
CDPO.
The
CDPO Tangi.
Child Development Officer, Child Development Program
Project,
Officer,
project officer.
Child Development Project Officer reached a conclusion that the appellant was not a resident of the area, Anganwadi area. Stop. The appellant challenged after setting aside the appellant's selection on that ground, the respondent number 5, who was second in the merit list, was selected and appointed and engaged. Stop. The appellant challenged the selection of respondent number 5 by filing an appeal before the appellate authority, which came to be dismissed with a finding that the appellant did not belong to the Anganwadi center area. Stop. Next, learned counsel appearing on behalf of the appellant has submitted that the finding that the appellant is not did not reside within the Anganwadi center area is incorrect. Post office submits that the appellant resides in the area of also Anganwadi Center, Patna Sai Anganwadi Center. Stop. Learned counsel for the appellant has further submitted that there was no requirement of a person being resident within the area covered by a concerned Anganwadi center. Stop. It is not in dispute. There being no dispute about the fact that the appellant was resident of the village in which Anganwadi, Patna Sai Anganwadi Center was established, the petitioner had the qualification to be considered for engagement as Anganwadi worker. Stop. Next, we have learned counsel appearing for the respondents have defended the impugned judgment passed by the learned single judge. Stop. we have perused the impugned judgment of the learned single judge and have given our thoughtful consideration to the rival submissions advanced on behalf of the parties. Full stop. The CDPO, upon an inquiry, reached a conclusion that the petitioner was not a resident of the area covered by the Anganwadi Center. Full stop. The said finding of the CDPO has been affirmed in appeal by the appellate authority. Full stop. Learned single judge, comma, in our opinion, has rightly hailed in the impugned order that since the appellant was not a resident of Anganwadi area, comma, on the ground that she is resident of the village, she could not claim her right of engagement in Patna Sahi Anganwadi Center. Full stop. Learned single judge has noted that the Anganwadi Center has been finalized by the standing committee. Full stop. Learned single judge has rightly hailed that the appellant, since the appellant does not belong to Anganwadi Center area, her claim could not have been taken into consideration. Full stop. Consequently, we do not find any, resultantly, we do not find any merit in the submission advanced on behalf of the appellant. Full stop. This appeal has no merit and is accordingly dismissed.
My lord,
Item
about manipulation of the document, my liberty to take appropriate forum regarding, as my lords said that criminal action is,
A learned counsel for the appellant has also argued that the documents have been manipulated to deny the appellant's right of engagement as Anganwadi worker. Full stop. We need not go into such disputed questions of facts in the present proceeding. Full stop. In the present proceeding, full stop, the petitioner may take recourse to appropriate forum if, according to him, any document was manufactured to deny the appellant's claim.
my lords. Oblige, great oblige.
You have been engaged by the senior counsel, I think. What is your name?
Yes, yes, I will, my name is Akhand, I will give my name.
Why are you shy of disclosing your name?
Yes, yes, my name is Akhand, my lord.
That's all.
Yes,
Akhand,
yes,
just one name.
yeah, one name, my lord. Yes,
So on behalf of Mr. Acharya.
Gautam Acharya.
item number 40.
oblige, my lord.
My lord, I want to invite your lordship's attention. Order dated 31st July 2023. Para 6.
Just a minute.
Having perused the order impugned in this appeal, we are of the view that this appeal be admitted and heard on merits. So I may proceed on merits, my lord.
Order number?
Order
dated 31st July 2023. Order number 5.
Yes.
I am permitted to proceed on merits of the case.
You have a right to proceed.
Yes. The issue is
Yes.
whether the appellants who are members of diploma empaneled civil engineers and their name find place in the merit list prepared by duly constituted committee of the state government are entitled for consideration of appointment under the old rules.
Yes, you are challenging which order?
Single judge.
Date?
Yes. It is at page 61. Date is 17 August 2022.
So you are challenging this order?
Yes, ma'am. Prior to this order, Division Bench of this Honorable Court, page 24 is the order, has decided the issue and they remanded the matter to the state tribunal to find out the vacancy. They say the state tribunal has not correctly find out the vacancy position.
No, what is the issue involved?
The issue involved is, my lord, they stopped giving us appointment despite of vacancies. Whereas the conscious decision taken at page 85 by the government, it says.
So you challenge the advertisement?
Yes.
On what ground?
On the ground that if you also see page 85, in which the amendment rules were kept in abeyance till 2018. But we were not giving consideration for appointment on old rules.
What is the old rule?
Old rule was there was a committee which prepared the select list, and out of the select list, the appointments were made.
How can you be appointed under the old rule?
Because that's what page 85 is the gazette notification itself. Page 86, the relevant. May I read one? Now, therefore, the exercise of powers conferred by Rule 19 of the State Orissa Diploma Engineering Service, Rules 2012, and in exigency of public interest, government, after careful consideration, do hereby relax the provision of the aforesaid rule till 31st March 2014. And as such, all appointments to the existing vacancies of junior engineers shall be made as were made prior to commencement of these rules from out of the panel maintained by the Committee of Chief Engineers and Engineer-in-Chief, Orissa. So, my lord, we mark the existing vacancies. This relaxation was utilized till 2018.
Please come to paragraph 21 of the judgment of the learned single judge.
Yes. This court, after going through the same, finds that though on 31st March 2014, the total vacancies available was 2,773. But in terms of Annex 2, requisition were received in respect of 1,869 posts. No direction can be issued to the state government to fill up the rest vacancies from out of the panel maintained by the committee. This court also finds no illegality on the part of state
So
government.
1869 posts were advertised.
No, 1869 were the vacancies they declared. Out of that, 1612 were filled. When this matter was before the High Court, they admitted that there are 445 vacancies are there with us, but they didn't consider us for the appointment.
So what is your right to be considered?
Right to consider, my lord, if there is a conscious decision of the state government that no, we will not fill up these vacancies due to one or any reason. Sankarshan Das Constitution Bench also says the same thing. There should be a conscious decision, but there is no decision.
Sir, counsel, we are again putting this question. What right do you have to be appointed against either of these 1869 posts?
1869, they filled up 1612. The vacancies were 2773, but they declared 1869.
So you were selected?
Yes, we were in the merit list up to 2012 when the rules were amended.
Not merit list, that panel.
Panel.
Earlier, the appointment was from the panel without any going to the for open recruitment. Here, they may not have considered your name and gone for recruitment.
Recruitment.
That has been done.
Yes.
You want to say that the old practice should be followed in your case. That
Because-
government was asked to consider.
Because they followed it till 2018. For that, I have.
Because there was some relaxation of the rules for a particular period.
Yes. The notification was up to 31st March 2014, but they went on relaxing the rule till 2018. So what harm we have done?
So you wanted relaxation after 2018.
No. The vacancy was existing. They followed the relaxation till 2018. Then we are hardly in the writ petition 200 something. Now I think 40 or something. So we should have considered for the.
Now we are again putting the same question.
Yes.
What legal right do you have to be appointed?
No vested legal right,
Then the matter is
but
over.
there is a discrimination. They have discriminated us. And your lordship and apex court also says, if there is a conscious decision not to fill up these vacancies by virtue of this, then I have out of
When were these posts advertised?
Yes.
When were these posts advertised?
Yes, I like the date. First, it was advertised on 30. I'll just. It was advertised in 4th August 2014. First.
You applied. You applied.
No, we didn't apply. Because
You didn't apply.
didn't apply.
Then
Because we are covered by the old rules, we went to the tribunal. Tribunal says the list is valid. It is the power of the government.
No. Why did you go to the tribunal? Because you were not appointed.
No, we challenge this advertisement, and another priority we should be considered under the.
your name is there in the panel.
Yes,
On what basis that panel was prepared?
that there was a committee of chief engineers who used to. There was a criteria that first division, second division will come in the select panel list.
So these things were being done in the office or without?
No, that was notified.
This
That
is what
com-
we are asking.
Huh.
How your name was there in the panel? This question we have been putting for last 5 minutes.
Yes.
Then
So
how?
I'll show the page, my lord.
Resolution or notification by which appointments were being made from the panel, please show that.
Yes. That is page 18. This was in the writ petition. Give it to both copies.
You tell us the annexure, we have the writ petition.
Yes, it says the under
Page.
page, my lord, that is in the writ petition.
1048.
8
Which?
8877/2017.
That is not clear.
So we intend to take away this liberty which has been given in paragraph 22 of the judgment. Because a panel prepared years ago cannot be used like a reservoir for filling up all the pores.
No, my lord, if you appreciate. Because
So that 22 will have, we will modify.
Immediately we challenge the order.
All right.
The High Court order, we approach to the High Court.
All
Kindly
right,
see
then.
the High Court's order that is at page.
All right, we have understood.
This order is at page, starts 24 and 49, the observation.
Yes.
It says
2022 SCC, online SC 860. Yes, tomorrow we will deliver judgment.
Well, I have some judgment, if you would like to consider on this.
Give your judgment.
Yes. And the single bench relied upon Anurag Sharma. The Anurag Sharma is in our favor, which says if there is a conscious decision, then we can direct the state to consider for appointment. I am giving the judgment. I have given a list of dates also that might help. This judgment has been followed in these cases.
Yes, we will consider them.
Nine. Bakita nine. Only one is there. That is state of Himachal.
Yes.
What is my submission is, my lord, they could have considered, but I don't know why they left us to lodge in the
Yes,
state.
what is there in this state of Himachal, Rajkumar?
Yes.
Anurag Sharma, this has been considered.
This has been considered by single bench,
Yes.
but it is in my favor.
Yes.
Last, there are guidelines have been stated.
Yes.
In which it says, if there is a conscious decision, that is the notification.
Which paragraph?
Paragraph last, there are 6 or 8. I have given my copy. Extra copy also.
Mr. Pal, have you given a copy earlier?
Yes.
This decision?
Yes.
Then you refer to this, we'll look at that.
That is page 56.
Yes.
3, clause 3. The government is entitled to take a conscious policy decision not to fill up the vacancies arising prior to the amendment of the rules. The employee does not acquire any vested right of being considered for repeal rules in view of policy decision taken by the government. My submission is, in my case, no conscious decision was taken not to fill up this post. Then 5. When there is no statutory duty cast upon the state to consider appointments to vacancies that existed prior to the amendment, the state cannot direct it to consider the case. In my case, by notification, page 85 of the appeal, they say the existing vacancies should be filled up by the old rules. And one more thing I would like to show, madam, that how they themselves have flouted this rule.
Yes, so you have made us to read page 56.
Yes, 56. And they have quoted Deepak Agarwal's case. That is also in my favor, that page.
Mister, you have read 56.
Yes, that is their conclusion. I am covered by that.
Rangaiya.
Rangaiya was, they say Rangaiya will not be applicable. They overruled the Rangaiya.
So if Rangaiya is overruled, Rangaiya has been referred to in page 56.
56.
Page 56. The decision rendered in Rangaiya has been noted. Findings of Rangaiya.
No, it says, sorry, a review of the 15 cases that have distinguished Rangaiya would demonstrate that this court has been consistently carving out exceptions to the broad proposition formulated in Rangaiya. The findings in this judgment that have a direct bearing on the proposition formulated by Rangaiya are as under.
Yes. And then
they have referred another Deepak Agarwal's case.
Yes.
That is at page.
So the law is very clear in paragraph 37.3. The vacancies which occurred prior to amended rule would be governed by the old rules and not by the amended rules. Does not reflect correct proposition of law governing services.
That was Rangaiya and all. They followed that if vacancy occurred prior to amendment.
That has been clarified.
Yes. Then 37.2 may kindly be seen. The decision in Deepak Agarwal is a complete departure from the principle of Rangaiya, inasmuch as the court has held that a candidate has a right to be considered in the light of existing rules, that is the rule in force on the date of consideration takes place. The enunciate is followed in many subsequent, including Union of India, so and so. There is only a right to be considered for promotion according to rules which applicable date on which consideration of promotion takes place. Rangaiya's operative portion.
All right, we have understood this. Next submission.
Next submission, my lord. The Sankarsan Das Constitution.
Sankarsan Das. How Sankarsan Das has application in your case?
Because they left some vacancy with the policy decision that this should be filled by scheduled tribes. Therefore, Sankarsan Das could not find it place for consideration. They say that there should be, the government cannot fill up the vacancies on their own whims. There should be a policy decision, conscious effort that this vacancy should not be filled because of this. That is not present in my case. And another, they have admitted before the High Court, before single judge, that there are 445 vacancies are there.
Yes, we will restrain them from filling up those vacancies from that panel. They cannot do that.
But this,
yes, state.
This judgment says, my lord.
Yes, ma'am. So far as that judgment is relied upon, that overrules the Rangaiya decision. The Rangaiya decision said the old rule governed the field at the time of vacancy arose. That subsequent judgment said that the rule governing the field, even if the vacancy arose prior to that, the rule governing the field will govern the field. That is the decision of that my learned friend has relied upon. I will clarify my lord's only numbers. Right? They are emphasizing that all the posts are not filled up. Okay, let's me turn to that judgment of the Honorable Single Judge. Let's me para 17.
Annexure?
Para 17, your lordship got it, para 17
Yes.
of the honorable single judge judgment.
Page.
The-
It's annexure. 5.
What has happened there? They have given me a copy. Your lordship can find it that it is renumbered as 49, 80.
Annexure. Annexure.
Read that.
Yes.
Lordship got it.
Yes.
It is also submitted that in view of annexure 2, unless and until sufficient requisitions are received by the committee from various departments of the government, the committee cannot and is not in a position to sponsor any candidate from the panel. Even though by 31/3/2014 requisitions to the extent of 1869 posts were received and sponsored, but government decided to fill up 1612 posts. Well, I pause there. Why 1612 posts were? That has been clarified in paragraph 10 of that judgment, my lord. 1612 and 257 belongs to SC and ST due to non-availability of the SC and ST candidates. Their names were not sponsored. So government filled up only 1612. Even if 2773 vacancies are there, government fills up the vacancy as per the sponsor, as per the requisition made. Requisition made was in respect of 1869. So 252 vacancies could not fill up as SC and ST candidates are not available. So subsequently, that notification that prior to 2012 there was no rule. In 2012, a statutory rule was made under Article 309 of the Constitution of India, and that has been given effect from 31/3/2014. And as per the provisions made under that statutory rule, an advertisement was made, and in accordance with that advertisement, all the appointments have been given in the meantime.
All right. Yes.
My lord, we would like to see how they relaxed in 2018. In the 2018, another judgment came from the tribunal. They relaxed the rule. That
Yes. Tomorrow for judgment. 2 p.m. Never will repeat it. Okay. Right.
May I be pardoned, my lords? May I be pardoned, my lords, to mention item 49?
All right.
Item 41.
Next week, as requested.
Item 42. 42.
May I please, Your Lordship? Your Lordship, in this writ appeal, the order passed by the opposite party, my lord, opposite party already ready to unseize the account, my lord, because the outstanding loss already paid by the petitioner.
So this has become infructuous.
Yes, Your Lordship. Your Lordship,
It is stated.
Have you
by-
done it or you will do it?
do it.
So 1 week, as requested on behalf of the opposite opponent, let's this matter on 1 week. In the meanwhile, you do it.
Yes.
Item 43.
Now, kindly grant some time to file a reply to the rejoinder affidavit. Grant some time.
The reply to rejoinder.
No, no, because there are some facts, my lord,
It
which is not been
stated
prevailed.
by Land Council appearing on behalf of the opposite respondent.
Only prayer is a date may be fixed, Your Lordship.
Sir, that is being
On
fixed.
behalf
not
of the,
getting-
your respondent.
My lord.
Respondent. State. Opposite party or respondent?
Opposite party.
Opposite party. That in the rejoinder affidavit filed on behalf of the petitioner, certain new facts have been brought on record, which are required to be dealt with. First off, he intends to file an affidavit to deal with the facts averred in the rejoinder affidavit. stop for the said purpose, comma, as requested, comma, the matter is adjourned to 1 week.
1 week thereafter. Otherwise, my suggestion would be let them serve the copy on us within a week, so that the following week we'll be ready with
This
everything. and-
matter on
Ma'am.
2 weeks. 1 week you.
Mile.
Item
Rolex.
44.
44, my lord. Landfront has filed quite a voluminous counter 2 days before.
What do you
I'll
want?
go through it 1 week after.
Learned counsel for the petitioner. Petitioner, appellate seeks adjournment to consider the counter affidavit which has been filed
OP number, respond number 5.
recently on behalf of OP number 5. So as requested, list this matter on
1 week after.
1 week.
Any day.
Item 45.
Item 40.
Pardon, Your Lordship. I beg your pardon, Your Lordship. Item 42, Your Lordship, the observation, it may be observed, Your Lordship, the contention.
Let
made
it
by-
come. The fair counsel, once he has
Kindly directed to comply, file the comply certificate, so that we.
Complaint with the contempt measure.
Any contempt nahi. Your Lordship,
do whatever you want to do on the next week, we'll see.
Item 45.
Because we don't know.
only the submission made by my learned senior may be recorded.
Let it come.
Item 45, my lord, I am on behalf of the state, day after, I pray day after tomorrow. That instruction.
As requested on behalf of the estate, list this matter on day after tomorrow.
My lord,
46.
my lord, may I request, my lord, day after not, next week, any date, my lord.
As requested on behalf of the petitioner, list this matter
Your
on
Lordship, item number 40.
1 week. 1 week, yes.
Much obliged.
Your Lordship, item number 46, we have instruction to appear for CMC.
46 was appearing.
I am for the petitioner one.
Yes, he is seeking adjournment.
No, we will file the wakalatnama.
Oh, file wakalatnama, then you should be happy.
46, it's a public interest litigation.
The public interest litigation,
Yes, on
Then-
46-4, Your Lordship.
we will see. We'll take up later.
Which opposite party?
OP number 6.
You may do that. Yes, we are adjourning for a week.
May I please, Your Lord, 46, I have entered appearance for OP number 8. Let him serve me a copy.
Notice was issued.
No, notice was not issued to OP.
Yes.
OP number 8.
I'll solve by tomorrow.
My lord, I am from opposite party number 2, I am filing the wakalat.
File your wakalatnama in registry. List this case on 1 week. The parties in the meanwhile shall be at liberty to file their counter pleadings. Yes.
Item 47.
May I please, Your Lordship? My lord, here in this case, the present petitioner is a 19-year young boy, file is an aspirant of JEE main examination, or with a very limited prayer that to change his category is category in the common application form, my lord, and the matter is before listed and matter posted for the instructions from the opposite party.
No, which examination?
My lord?
Which examination?
My lord, for the change of the category, that is the person belong to general EWS, economic weaker section, but inadvertently which is mentioned as general category. For the change of the same, the prayer is, my lord, that is that much prayer is there, my lord.
How that can be done?
My lord,
Who is for the other side?
My lord, we are for the other side, my lord, I pray, my lord, can it may be taken up tomorrow, my lord? Because
Pick up
of the-
tomorrow. Just examine. It is very difficult to change the
my lord,
category.
in that light, I have mentioned 2 decisions. My lord, my only submission, there is 7 rounds of counseling procedure is there.
All
And the last procedure, you have to submit the,
So when did you obtain your EWS certificate?
my lord, in the meantime. My lord, the EWS certificate is only valid for 1 year. So that's why when you applied for, you have to apply that at the time of the admission. The admission is not yet
No,
started.
whether at the time of filling of the form you are required to mention that or not.
My lord, but that is that in I have 2 decisions. So my lord, I am before your
We'll see.
lordship.
Yes. Next.
Tomorrow.
Tomorrow.
Applies.
Item 48.
Item 48, my lord. I have received the counter and I have prepared the agenda. Only 1 week may be granted for
As
filing.
requested on behalf of the petitioners. This matter on.
My lord, in this
This is regarding what?
nursing matter.
Nursing, why should it?
No,
not
no,
be?
my lord, that type, these cases are not that type. my lord. In this case, I have submitted the application on time and they have not inspected our institution for issuance of
So
NOC.
whether they can issue NOC or not, that is the question. So in any case, this can be carried on.
No, I am not claiming in this for this academic year.
This is
I am
for
claiming
24-25.
For 25, my lord.
425.
25, my lord.
You applied in time.
I have applied. They have given some deficiency and that deficiency have complained. So offline, they are not accepting through offline due to some technical irregularity in online. I submitted
My lord.
through offline. They are not, though they have accepted offline application, but they are not.
My lord,
inspected
their case
our
is the 6 number of cases continuously. Their cases, deficiencies were been communicated to them, wherein it was mentioned that they should reply with the email address given to them. Instead of giving an email, they have given a hard copy have been sent within 14 days. So that's why we have not accepted taking into consideration my lord's judgment. If you take near about 60 to 70 institutions are coming who have not done as per our instruction in time. So if you go out of time, so the admission will be derailed and we cannot get the admissions, everything done in time as per my lord direction.
No, but they saying that there is some technical glitch.
No, my lord.
They have admitted in their counter. I have clarified.
No, my lord, we have given them, they have given hard copy on the last date, which was given to them within 14 days, they have to give by online.
They are saying because of some technical glitch,
Mine.
you could not give online.
My lord.
No,
Then
but that is not been told to us. So only thing is that,
Tomorrow we will take up.
yes, my lord.
My lords, we'll all file rejoinder, my lords. Almost
Only 2 to the Monday, my lord.
Monday.
As requested on behalf of the petitioners, these matters on Monday.
Monday.
My lord, the last three items, 1 week type may be given because I have got the instructions there for inspection. In 2 cases, I have got instructions in the
So
3rd
1
case.
week, all the cases will come out.
Yes, ma'am. No, please.
Item 49.
May it please my lords, with your lordship's kind permission, may I appear online for your lordship's kind permission, my lord? My lord, very grateful to your lordship. This is a matter, my lord, where your lordships were kind enough to issue a short notice, my lord. On the 12th of June, your lordships issued notice. And then if your lordship just kindly see the order dated, my lord, 19th of June, there your lordships have, my lord, given a slight indication of really what the issue is. Give me 19th of June.
No, you are appealing for the petitioner.
I'm appealing for the petitioner. On the 12th of June. I'm sorry. If your lordship just look at the 12th of June order, my lord. Paragraph 2. If your lordship kindly see.
Yes.
Mr. Muduli Learned Counsel files Vakalatama on behalf of the OMC, my lord. That is OP 2 and 3, which is taken on record. He, however, submits that the petitioner is prohibited to take part in a national e-auction for the year 24-25. An affidavit to that effect shall be filed within a period of 7 days, if permitted. My lord, my distinguished colleague, Mr. Das, is also appearing in the matter, my lord. He drew attention to subclause F of clause A of the general principles of long-term linkage, policy of minerals for Odisha-based industries through OMC, my lord, and submits that in the national...
What do you want, Mr.
I'll tell you, lordship, the problem, my lord, is I am twice barred. They have first barred me, my lord, from the state long-term linkage policy. I have a 5-year long-term linkage agreement with the state government valid from 2022 to 2027. They have barred me, my lord. I'm a manufacturer.
Mr. Michel, let us be clear on the whether we should take up the matter for final hearing or pleadings are complete.
My lord, pleadings are complete as far as OP 2 and 3 is concerned. OP 1, which is the state, has not filed a counter. All I am requesting your lordship is, my lord, your lordship may, my lord, of course, subject to my lord's convenience, take up the matter at any point. It's a very short point, my lord. All I'm requesting is that, my lord, these auctions, these national e-auctions are held every month. Now, my lord, my plant, I have 2 plants. Both my plants today are closed because, my lord, this ferro chrome, my lord, the chrome ore itself is a totally, my lord, the item which is in short supply. Unlike iron ore, manganese ore, bauxite, my lord, which has a lot of merchant mining supply in the market. Ferro ore, this is an ore, my lord, chrome ore is absolutely in short supply because 90% is available, my lord, very fortunately in Odisha. And out of that 90%, OMC has 1/3 of the reserves. They are the only merchant miners. They have, my lord, a long-term linkage policy.
Mr. Mishra, we can fix
Yes,
the
sir.
matter for final hearing once the affidavit is filed on behalf of the estate on a particular date and with a time, specific time. We can take up the
I'm
meeting
very
at 2
grateful. Your
p.m.
lordship,
That can be done.
very grateful. I'm very grateful. That would be perfect, my lord, if your
three-
lordships could kindly, my lord, indulge
3
us on that.
weeks, your lordship, for affidavit.
He's seeking adjournment for 2 weeks. That can be granted.
Yes, your lordship. 2 weeks.
My lord, OMC
Because
has filed
OMC
an
is the
affidavit
main
within
contesting
4
party.
days.
They have
Why should the
filed, so
state,
we'll file a reply within 2 weeks, your lordship. 2 to 3 weeks, 3 weeks maybe.
No, 3 weeks.
why should it take so long? It's a very short point.
File your affidavit.
Because the next e-auction, otherwise I'll be barred again from the next
My
national
lord,
e-auction, which will
OMC
be in
has
the middle
filed
of
the
July.
affidavit.
All right.
The main contesting party is OMC.
State has no role.
No, state has the
State,
role.
my lord, state has, my lord,
So
state
the
has a
state
limited
committee-
role as far as
state
the long-term
committee has
linkage
not
policy is
granted
concerned.
What
Do you want to file counter? Yes, your lordship. We'll file a counter.
State committee has not granted them.
All right. Is this matter on 2 weeks to be taken up at 2 p.m. for final hearing? Stop. In the meanwhile, the state opposite parties shall be required to file their counter affidavit. Opposite party number 1 shall be required to file counter affidavit. Yes.
Item
Would
50.
your lordship give a returnable date, my lord? Would your lordship?
9th.
9th.
9th? Very
Your
well.
matter will be taken up at 2 p.m.
Very well. Very grateful to my lord, deeply grateful.
Yes.
Just now I received the so-called reply. So let the matter go next.
50.
Item 50, 50.
Whether order has been complied with or
No.
Yes.
Some part payment they have given.
He has
I'm
already.
satisfied. I'm satisfied they have not complied. I have due, my due as per calculation. As the award on the London Labour Court, near about 12 lakhs. They have only paid 1,30,000. Up to I have to take instruction whether they have paid or not. Then let the matter next week.
as requested on behalf of Land Council appearing on behalf of the contemners. Contemner has submitted that this court's order violation of which has been alleged has been fully complied with. Stop. And counsel for the petitioner seeks adjournment to examine whether there has been compliance of this court's order or not. As requested by, on behalf of the petitioner, list this matter on 1 week.
Madam.
Yes.
You appeared for the contemners?
Madam.
Where?
Madam, I have appeared on my line.
All right. No.
28/3/2020.
All right. Name is not there. All right.
My power is not there. My
Here,
name.
you have filed wakalatnama.
Yes, I have the receipt.
Yes.
Special list item number 1.
Madam, one thing, I have filed the so-called compliance certificate.
Compliance certificate has been filed on behalf of the contemners, which has been taken on record. Yes.
Special list item number 1, CONTC 485 of 2003.
Appears dismissed.
Item number 2.
Item 2, the petitioner do not want to press this application, Your Lordship.
No,
I'm filing the
no,
memo
press.
to that effect.
Item number 3.
My lord, this contempt arises a matter relating to recovery matter in Mintrim order matter. In the meantime, REIT application was disposed of, and the judgment was passed. That judgment was not implemented. Another contempt was filed after receipt.
But this contempt application has become effective.
My lord. The judgment was passed. They are now not implemented. Then petitioner file again another contempt implementing the judgment. After receipt of notice, they have gone to Supreme Court. The Supreme Court, they lost the case on 16/4/2024. You know, so this contempt application arises before this court in interim order, my lord.
So therefore, that has become infractuous.
Another that contempt may
That contempt matter, you can press that.
that contempt number is
Let that come. Let that come.
768.
Now only old matters are listed.
Yes,
because most of them
that
may
is
be-
also 2018 matter.
The present contempt application arises out of an interim order passed by this court in WPC number
13961 of
2013.
13.
Supplement counsel for the petitioner has informed this court that the said writ petition has finally been disposed of by a learned single judge.
Yes, my lord.
By a learned single judge of this court. Full stop. And the matter went to the revision bench.
No, thereafter, finally the writ application was disposed of with the judgment. Their judgment was not implemented. They have again filed a contempt application bearing this number, my lord. After receipt of notice and personal appearance made, they have gone to Supreme Court.
Against the order of the learned single judge.
Single judge. That was finally disposed of on 16/4/2024.
They must have been remanded back.
No, my lord. Already, finally, they modify that order. Modify order and directed to implement the order from order of the Honorable Supreme Court, earlier Supreme Court order, that is 19/3/2003.
So, in such view of the matter, we are not inclined to proceed in the present contempt matter. And counsel for the petitioner has submitted that the order, final order passed by this court in WPC number so and so is not being complied with despite dismissal of the SLP by the Supreme Court against the said order. Stop. And the petitioner shall be at liberty to pursue the said contempt application as and when the said matter is taken up.
That contempt application also earlier order passed by Honorable Single Judge that put up this contempt application before after final order of the Honorable Supreme Court.
So you pursue.
That is also 2018 matter, my lord.
And you have one more difficulty, we must tell you, that because the order of this court has been modified by the Supreme Court,
yes,
then that order merged with the order of Supreme Court. And then for contempt, you will have to go to Supreme Court. That is the difficulty. Yes.
Item number 4.
In contempt application, I have no instruction. In a contempt, in a read application, my send
Sub-item or read manner, and read application has been disposed of, that order has been implemented and the petition has got appointment. In practice.
And I don't know for.
Well, I don't know for. So I am in read WPC.
First one, no instruction. That
in a when
RA scheme appointment was sought for. Government had issued instruction to give him appointment by creating a vacancy who was irregularly appointed. So he has been given appointment.
I have got appointment.
It is not in dispute. It is not disputed at the bar that the order of this court, violation of which has been alleged in this case, has been fully implemented. Also, what about WPC records have come out?
A contempt, my lord, they have not complied with the earlier order. For that reason, I file a contempt. When the contempt application is pending, the writ application is filed.
In contempt petition, my lord has filed. Government has rejected. Against rejection order, I filed the read petition.
petition pending or it is disposed of?
No, it's pending. Also, it's a single bench matter because
Pendency government has complained.
yes, in the meantime we have complied, so it has become infructuous. In fact,
now it has become infructuous.
WPC number.
Yes,
the read petition has become infructuous. The petition has not happened.
For the petitioner has also submitted that WPC number 7421 of 2017 has become infructuous because of the because of subsequent development. Full stop. Subsequent development in as much as the petitioner has been appointed
under rehabilitation assistance scheme.
under rehabilitation assistance
Scheme. Yes.
scheme. Full stop. Though WPC number 7421 of 2017 has not been listed.
No, it is there not for reference only.
Huh? It is listed. All right. In such view of the matter, WPC number so and so stands disposed of as having become infructuous.
Item number 5.
So SETI 2013 WBC?
No, 2013 WPC was disposed of, Lords. Against that, he had filed a contempt. And during pendency of the contempt, another writ application was filed, Lords.
Disposed of. No
Yes.
noting is there, that's why I asked.
Right.
Yes. Disposed.
Item 5.
Yes, non-appears dismissed.
Item number 6.
I'm ordered.
Item number 7.
Lord, the contempt application has been infructuous, my lord.
Infructuous as stated.
Item number 8.
8 may it please the Lordship. Lordship, in this matter, the contempt application has been filed because of the willful deviation from the order passed by this honorable court, my lord. In this matter, particularly due to the severance of the matter, this honorable court has directed the registrar, learned registrar, inquiry and investigation to inquire this matter, my lord. This is on the record, my lord. On the last occasion, I have requested your lordship to take this matter on the main list because the writ petition is also pending and there is an inquiry by this honorable court from the registrar, my lord. The inquiry report is with your lordship. The writ petition is also pending and there is severe allegation of tampering of the records also, my lord. Missing of records that is there in the lordship's record. I only
So what
pray,
do you want?
I only pray, my lord, if your lordship will take up this matter in the main list.
So what is the difference between main list
My
and
lord,
this list?
I'll be more prepared if I say, my lord, in the main list, my lord.
No, the date will be prepared. You want more
My lord,
time?
my lord, my lord.
As requested on behalf of the petitioner listed in these matters on 2 weeks.
Item number 9.
Here is the matter. The deliberate disobedience is writ large in the face of record, my lord. I have filed one reply to the first affidavit, so-called affidavit they have filed, that is at flag X, my lord.
Now let us see the order.
The order is, my lord, a bank guarantee is to be deposited. That the order is, my lord, at
Page 10.
page 10, my lord. The operating part of the order, my lord, at page 23, my lord. Para 16. Accordingly, without expressing any opinion on the merits, we direct the petitioner may be permitted to remove the stored material on furnishing bank guarantee of the value equal to the value of the materials as may be determined by the director of mines within 2 weeks from today. Having stipulated that the state's guarantee will be kept alive from time to time, the court where the proceeding is pending may be concluded the proceeding within 6 months. My lord, here thereafter, we have time and again sent letters to the
No, let us see. Without, let us read paragraph 16. Please read it.
Paragraph 16, my lord. The court where the proceedings are pending may conclude the proceeding within 6 months. The petitioner will be entitled to raise all the contentions before the said court. The petition is disposed of. The order will not debar the party protest from taking such steps as may be permissible under the law for recovery of residuals. The issue of liability of the storage place may also go on into the trial court. So after filing of this, my lord, the bank guarantee.
Which part has been violated?
The court where the my lord, the petitioner may be permitted to remove the material, my lord, after
On furnishing bank guarantee
my lord.
of the value if determined by the director of mines.
Yes, my lord.
Yes.
So we were not allowed to lift the material. Yes,
The
furnished.
amount was determined.
The quantity was determined, my lord. Kindly see, my lord. They have filed a so-called affidavit. Then thereafter, what happened? I had filed the reply. So detailed I have mentioned in my reply is under, that is at page, that is at flag 6.
No, but just tell us from the order.
Yes.
You are alleging disobedience of the order.
Yes, my lord.
So this order says that you shall be permitted to remove the stored material. 1.
My lord.
On furnishing bank guarantee. 2.
My lord.
Of the value equal to the value of the material as may be determined by the director mines.
Yes.
3. Within 2 weeks. So as may be determined, you shall be permitted to remove the.
Yes, my lord.
So whether the determination was done.
Yes, determination was done, and I have filed then, pursuant to the determination, we have filed the bank guarantee, we have submitted the bank guarantee with the DDM, and thereafter it was not lifted. They were not allowed to lift the material.
Who
said? The director mines, my lord, the container number 1.
Bank guarantee has to be kept alive.
So he did not allow you to.
Yes, lift the material.
Lift.
Yes, material.
Where is that?
That is, my lord.
If you
Kindly
lost
see.
it-
Kindly
if you lost it-
Just a minute.
Kindly see.
Just a minute. Yes, and some matter was pending before the court.
That trial court. The trial court that has been disposed of.
Then there's no contempt.
No, that is, they were not allowed to, the content, my lord, my contention is that they were not allowed to leave the material on submission of the bank guarantee. That was the categoric direction that the bank guarantee, when we have
So
submitted, they should allow
an
us.
admitted fact that you were not permitted. They admit
Yes.
that they did not
Yes,
permit
in
you
the
to
first
lift.
so-called affidavit, they have stated that there is some delay, and the delay has not been intentional. So it was, the proceeding was dropped. Then thereafter, they have not allowed again. They said before the court, they came and appeared before the court and said that it was not intentional. So the proceeding was dropped. Then thereafter, they again delayed. They were not allowed. So again, they were called for. So I have mentioned all these, my lord, in my reply rejoinder affidavit. That is at page 6, at flag X.
Yes, is it true, Mr. Sahni?
No, Mr. Lordship, may kindly come to my so-called affidavit dated, Lords, that is 23rd of August 2023. In paragraph 4, I've given everything. He has been allowed, he has also lifted. Mr. Lordship, may kindly come to that. Now he is
I have
contradicting that.
given, in the last occasion, they have stated so. I have filed a reply to that the categoric order of this honorable court has been violated because another affidavit they are supposed to file saying that why they have not followed. There was a 27/2/2015 order. That is at paragraph 6.
No, whether you have lifted it or not.
I have lifted.
Then what
No, my lord, the difficulty is that the categoric order of this honorable court has not been followed.
That will.
We have,
Just a minute. Now, in the present contempt application, the petitioner alleges disobedience of an order of this court dated 9/5/2014, passed in WPC number 3516 of 2014, operative part of which reads as under. Last paragraphs, paragraph 15, paragraph 16. Stop. Next, it appears that there is no dispute about the fact that pursuant to this court's order, the value of the material was determined by the director mines, based on which the petitioner had furnished bank guarantee and was finally permitted to remove the stored materials. Stop. Next, learned counsel appearing on behalf of the petitioner has submitted that though the petitioner was subsequently permitted to remove the stored materials, it's a case of gross violation of this court's order, in as much as the contemners did not adhere to the timeline prescribed by the court.
The timeline, and again the contempt here, again it was recalled. The proceeding was dropped and it was again recalled. So your lordship is correct. My lordship may kindly see at para 11 of my result affidavit.
All right, these are petty matters.
No, my lord. The time and again they have done this. Earlier occasion also there was another writ petition. They have violated.
See, Mr. Counsel, this is purely between the court and the contemptor, whether to proceed or not. We understand in which case we should take action, which case we should ignore. All right.
Section 13, there is a direct interference in the carriage of justice.
You're right.
Direct
Counsel
interference.
for the petitioner has attempted to convince this court that the contemptor have deliberately disobeyed this court's order, and therefore they deserve to be appropriately punished. Full stop. Next, after having seen the compliance affidavit filed on behalf of the contemptors and other materials on record, and taking into account the entire facts and circumstances in totality, we are not inclined to proceed further in the present contempt matter. Stop. The contempt proceeding stands stopped.
Item 10.
One line observation may be made that the same contempt violation may not be made in future, because repeatedly it's been continuing in that. I have avoided all those things.
We'll see in the next case. Yes.
Item number 10.
Please, your lordship.
Yes.
This is a straight violation of this honorable court's order.
Yes.
My lord, the order is at page 16, the modified order, which is the final order. I'm reading this.
Yes, whether order has been complied with, Mr. Samanth.
Yes, in fact,
As requested on behalf of the contemptors,
week,
this matter on next week.
no.
Some review petition and check.
Yeah, so got the list just now. Is records now.
Some review petition has been filed.
Yes, well, review petition 41 by 2015.
But the copy has not been served to us.
Give him.
They have not served.
Give him a copy of the review petition.
Yes, no. I will give a.
Give him a copy today.
Yes, yes.